Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen. Amen. Namaste.
Oath or affirmation, announcements by the Speaker, bills brought from the Senate, petitions, papers.
The Minister of Finance.
Madam Speaker, I have the honor to lay the annual report and audited financial statements of the First Citizens Investment Services Limited and its subsidiaries for the year 2018. I beg to move that this paper be referred to the Public Accounts Enterprises Committee.
Members, the question is that paper 1 be referred to the Public Accounts Enterprises Committee. All in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I have the honor to lay the following papers. Paper number 2, the ministerial response of the Ministry of Finance to the 15th report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the Youth Training and Employment Partnership Program for the financial years 2008 to 2014. The ministerial response of the Ministry of Community Development, Culture and the Arts to the 14th report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the National Commission for Self-Help Limited for the financial years 2008 to 2015. Thank you very kindly, Madam Speaker.
Reports from committees.
The member for St. Anne's East.
Thank you, Madam Speaker. Madam Speaker, I have the honor to present the 10th report of the Joint Select Committee on Human Rights, Equality and Diversity on the treatment of detainees at the Immigration Detention Center. Thank you.
The member for Caroni Central.
Thank you very much, Madam Speaker. I have the honor to present the 20th report of the Public Accounts Committee on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial year 2017.
The member for Caroni East.
Madam Speaker, I have the honor to present the 16th report of the Public Accounts Enterprise Committee on the examination of the audited financial statements of the Trinidad Tobago National Petroleum Marketing Company Limited for the financial years ended March 31st, 2008 to 2017.
Prime Minister's questions, urgent questions.
The member for Coover South.
Thank you very much, Madam Speaker. To the Minister of Rural Development and Local Government, given the revelations which were made at the Joint Select Committee meeting held on Wednesday, the 12th of February 2019, concerning the unavailability of financial officers on the local government establishment on several local government bodies, could the Minister inform this House what urgent measures are being employed to address this deficiency?
Minister of Rural Development and Local Government.
Very kindly, Madam Speaker. Madam Speaker, on behalf of the Minister of Rural Development and Local Government, the position of financial officer on contract was advertised in the Guardian and Express newspapers on February 13th, 2019, and will reappear on February 17th, 2019. The closing date for applications is February 24th, 2019. Immediately thereafter, the shortlisting of suitable candidates will be undertaken and interviews conducted. In addition, in order to facilitate a more appropriate package in order to attract and retain suitable candidates. Ministry officials met with the Chief Personnel Officer on February 14, 2019, in order to bring additional understanding of the role and responsibilities of the position and the challenges faced in recruiting efforts in the past. Thank you, Madam Speaker.
Supplemental, member for Couva South.
Thank you very much, Madam Speaker, and to the Minister or the Leader of Government Business, who is part of a cabinet which is committed to transparency and accountability as it relates to how taxpayers' monies are spent. Could the Minister...
Order. Order. Continue, Couva South.
Could the Minister inform this House if she's aware of how 300 laborers were employed at the Diego Martin Regional Corporation via blank forms which gave employment
Member.
up to October 2016 until further notice?
Out of order. Member for Oropuch West.
Speaker, to the Minister of Agriculture, Land and Fisheries. In light of the Minister's statements on Sunday, February 10, 2019, that inferior imported chicken is being sold within the local market, could the Minister indicate what quality control measures are in place to prevent the importation of inferior chicken into our markets?
The Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam Speaker. On behalf of the Minister of Agriculture, Lands and Fisheries, the answer is the Ministry of Agriculture, Lands and Fisheries and the Ministry of Trade and Industry are very vigilant regarding the importation of poultry into Trinidad and Tobago. Recognizing the problems created by the absence of a restriction on the shelf life of processed chicken, Cabinet in 2018, that's last year, approved a new policy under which chicken sold in Trinidad and Tobago must be no more than 180 days from date of slaughter. At this time, the Ministry of Agriculture, Lands and Fisheries and the Ministry of Trade and Industry are working with the USDA, U.S. Department of Agriculture, and other exporters to implement this change to conditions to which chicken will be allowed in Trinidad and Tobago. So those were the actions we were taking since last year, Madam Speaker.
Supplemental, member for Oropuch West.
Honourable Minister, how was it then that this container of chicken was able to be cleared and sold if it was not of the standard?
Minister of Agriculture, Land and Fisheries.
As I said in the body of my answer, we are now working with the USDA for the first time to implement new rules. I may add, Madam Speaker, and I'm glad that the member asked a supplemental, it was left to this government to approach the USDA, and may I put on record, between the years 2011 to 2015, no action. No. May I repeat, there was no action taken on the issue of imported legs and thighs especially. And the importers got 20% of the local market, thus negatively affecting local poultry producers. And this government took action in 2018. Thank you very much, Madam Speaker.
Member for Caroni East.
To the Minister of Education, with reference to the recent electrical problem at the beach camp facility in Palo Seco, where 242 pupils of the Santa Flora Government Primary were being temporarily housed, could the Minister state when will it be repaired and at what cost?
Thank you very much, Madam Speaker. As Acting Minister of Education, I put the following facts onto the table. A contract to fix the electrical system was awarded to MTS to the tune of $543,000. Work started on February 1st, which is 2 weeks ago. Works are due to be completed by February 20th, all things being equal, and the school will be reopened on February 21st. Those are the facts. We have dealt proactively with the situation, and the children's education will recommence on February 21st, 2019. Thank you very much, Madam Speaker.
Supplemental member for Caroni East.
They might or might not be able to answer this, but since this is a temporary... No offense, Brenda, sorry. Since this is a temporary housing accommodation from the Santa Flora government, when will the Santa Flora government school be completed to bring back the students from Beach Camp to Santa Flora with a 35% completion in 2015?
Minister of Education.
Madam Speaker, that is an entirely different question, and if it is posed in the correct format, the appropriate answer will be forthcoming. Thank you very much.
Member for Pointe-à-Pierre.
Thank you, Madam Speaker. To the Minister of Health, given the newspaper report of Sunday, February 10, 2019, that 2 Marabella residents, one being a child, were refused medical care by the doctors at the Marabella Health Facility, could the Minister confirm the veracity of the report?
Minister of Health.
Thank you very much again, Madam Speaker. Madam Speaker, I normally give facts when it comes to the reporting of health matters in the newspaper, and very often I have to correct. But in this particular case, Madam Speaker, I will not and cannot defend the indefensible. I will not. The standard of care provided at the Marabella Health Facility in this instant case left a lot to be desired. A clerk took it upon him or herself to not refer the patient to a nurse or a doctor for triage. That is unacceptable, and I personally condemn that action. The full report in that incident, after all the interviews of all the staff at the facility, has gone to the CEO as of today. And I have communicated to the board and the CEO that this is unacceptable, and they are to take whatever action they deem possible, but following proper industrial relations practices and due process. Thank you very much, Madam Speaker.
Supplemental member for Faisabad.
Thank you very much for your answer, Minister. Minister, can you say, pending the definitive outcome of that report, whether any steps have been taken to ensure that a clerk doing the triaging will no longer apply in that instance?
Minister of Health.
Thank you very much. As I said, the clerk did not do the triage. The clerk simply decided upon him or herself not to refer the patient to a nurse or a doctor for triage. Based on the information that we have so far, this is not acceptable. And as I have said, the board will take whatever action it deems necessary following proper IR practices. Thank you very much.
Member for Barataria Sanwan.
Thank you, Madam Speaker. Minister of Health, could the minister indicate whether he has caused an investigation to be conducted into the claims of Kimraj Ramgohan in light of the North Central Regional Health Authority's press release on his treatment?
Minister of Health.
Thank you very much, Madam Speaker. Madam Speaker, in this case, is the opposite now. The investigation reveals the following. The patient was seen at 1:12 p.m. on Tuesday at the A&E. At 1:18, 6 minutes later, a senior registrar and several medical teams in the trauma unit saw the patient. At 1:20, 8 minutes after admission, the patient received an X-ray, bloods were taken, he was medicated, and got a CT scan. At 4:15 p.m. on that same day, he was reviewed by a specialist surgery team and an eye surgery unit. He got overnight observation. At 8:40 a.m. the next morning, he was reviewed. He was seen by ophthalmology, ENT, general surgery. More CTs were taken on his head, abdomen, and pelvis to determine the extent of his injuries. Further bloods were taken to determine kidney function, blood count, electrolytes, blood gases, and blood sugar to determine his response to the care. During his entire stay, he was under the care and control of a senior specialist surgeon, and he was subsequently discharged by his attending physicians, having deemed he was now fit to go home. At no time, as reported, was this patient denied care, and if you try to quantify the amount of care he got here, it is over $150,000 worth of care that the taxpayer provided to this patient absolutely free of charge. As the release from North Central said, he received world-class care, and in this case, I thank the doctors and nurses, because if no one thanks them, I thank them and I stand behind them on this particular case. Thank you very much, Madam Speaker.
Questions on notice, questions for oral answer.
Leader of the House.
Thank you, Madam Speaker. How did you know? There are 9 questions for oral answer. And Madam Speaker, as was said by the member for Oropouche East, and as is the custom, we'll be answering all 9 questions.
Member for Barataria.
Question 69 to the Honourable Minister of Health.
Minister of Health.
Thank you very much, Madam Speaker. The contractor terminated the contract effective 22nd February 2018. Currently, the Ministry of Health is engaged in the final negotiation of claim settlement. Given the termination of the contract by Bowie Batemar, Trinidad and Tobago Construction Company Limited, the Ministry of Health has developed a reprioritized list of equipment to replace the proposed MRI and PET-CT, which are investigative pieces of equipment, originally intended for the National Oncology Center, and to allocate the diagnostic imaging units in existing hospitals within the respective RHAs. This repurposed initiative will serve to replace existing equipment which is nearing the end of life cycle at the various hospitals. Additionally, this would provide significant benefits to the respective catchment populations in meeting the critical need for additional and modern diagnostic imaging technology, while still achieving the original mandate of the initiative to address the burden of cancer in Trinidad and Tobago through effective screening and early diagnostic of disease. The following equipment was installed and is to be installed at the National Radiotherapy Center, St. James. High-dose HER brachytherapy unit installed and commissioned in July 2017, over a year and a half ago. LINAC equipment to be installed by May 2019 and commissioned in June 2019. The equipment to be installed at each regional health authority includes 1. At the National Radiotherapy Center, the CT simulator with respiratory gating. At the North Central Regional Health Authority, the digital mammography system and stereostatic biopsy. At North Central again, 64-slice CT scanner with power injector. North Central again, digital general X-ray system. Eastern RHA portable X-ray machine. Eastern RHA mobile fluoroscopic systems, that is CARMS. Southwest 64-slice CT scanner. Southwest digital mammography system. Southwest mobile fluoroscopic systems. Northwest Tesla MRI unit, cassette type. Northwest again, mobile fluoroscopic systems. Thank you very much, and the other parts don't apply. Thank you very much, Madam Speaker.
Supplemental member for Carinese.
Honourable Minister, these equipment that you just mentioned to be sent to various regional health authorities and the St. James Center, were these equipment the ones that were supposed to be housed at the National Oncology Center?
Minister of Health.
As I indicated in my answer, that is correct.
Member for Oropouche East.
Thank you very much, Minister. You indicated in the beginning of your answer that the contract was terminated. Could you tell us the reasons for the termination of the contract by either party?
That is now before the powers that be for arbitration. I would not like anything I say in this chamber to influence those discussions one way or the other. Thank you very much, Madam
Supplemental
Speaker.
member for Carinese.
So as of now, Honourable Minister of Health, can the population expect anything that was what was supposed to be an oncology center that is no longer going to be there?
Minister of Health.
Thank you very much, Madam Speaker. Honourable member, if we had paid attention to what I said, the St. James facility will now be providing the bulk of services with the LINAC. We commissioned the brachytherapy unit in 2017, and when the other pieces go in there, that center will be for want of a better term, a mini oncology center. Thank you very much again, Madam Speaker.
Supplemental member for Barataria San Juan.
Would the minister indicate whether it will be prudent to have an MRI and a CT in Sandy Grande Hospital rather than just a portable X-ray unit?
Minister of Health.
On the issue of the CT, Madam Speaker, when I came into office in September 2015, the CT was already down for 6 months under your tenure. Already down for 6 months. We went out and procured a new CT, which will be finished in this year, whole new construction and all of that. So that is going to be taken care of because the people in Grande deserve a better level of service. MRI, we will look at that, and if we can do it, but the new Sandy Grande Hospital, which we are going to build, will have an MRI. Thank you very much.
Member for Barataria San Juan.
Thank you, Madam Speaker. Question number 70, Minister of Health.
Minister of Health.
70. Sandy Grande enhanced.
Sandy Grande enhanced. Yes. I'm answering so many questions today, Madam Speaker. Question number 70. The services provided at the center include 1, a GP walk-in clinic, 2, an antenatal care clinic, 3, postnatal care clinic, 4, family planning, 5, child welfare, 6, chronic disease, 7, a health office, 8, mental health, 9, dental, 10, ophthalmology and optometry, 11, pharmaceutical dispensing, 12, pharmaceutical counseling, 13, nutrition counseling, 14, wound care, 15, dressings, 16, phlebotomy, 17, point-of-care testing, 18, breastfeeding counseling, medical social work, dressings, podiatry, ECG services, radiology, ultrasound, minor surgery, domiciliary visits, wellness center with gym facilities, and health education. The answer to part B is the community services commenced on September 4th, 2018, with GP walk-in started on September 5th, 2018. The official opening was on Saturday, 12th January 2019. Answer to part C, the design and construction commencement date was on May 2014. Thank you very much, Madam Speaker.
Supplemental member for Barataria San Juan.
Yeah, Minister, I just wanted to find out the wellness clinic that was earmarked for the obesity management. I didn't hear it mentioned as a clinic. Could the minister indicate if that would be a priority, seeing that the NCD trust is occurring in our country right now?
Yes.
Minister of Health.
I did say after domiciliary visits, wellness center with gym facilities. But we are repurposing that wellness after the new diabetic wellness center model we have pioneered at North Central, which has proven to be very, very effective. So we are going to roll out that model, which we launched in 2018, to all the RHAs. That new model of diabetes having a diabetic wellness center. Thank you again very much, Madam Speaker.
Member for Barataria San Juan.
Question 71 to the Minister of Health.
Minister of Health.
Thank you again, Madam Speaker. Answer to question 71. The general opening times of health centers throughout Trinidad and Tobago is 8 a.m. to 4 p.m. However, certain health centers with extended hours are open until 8 p.m. or 9 p.m. Monday to Friday, and on Saturdays from 8 a.m. to 4 p.m. on Sundays and public holidays from 9 a.m. to 2 p.m. There are 3 health centers that open beyond 9 p.m., namely centers in Toco, Rio Claro, and St. Joseph. There are 3 health centers that have accident and emergency service for 24 hours, namely the centers in Cedras, Toco, and Rio Claro. The 2019 budget statement stated that a 24-hour service is proposed for 3 additional health centers, namely Grand Riviere, Blanchisseuse, and Cedras, not Moruga as stated in the original question. It should be noted that the Moruga Health Center was not identified for a 24-hour service in the 2019 budget, but is being considered for this type of service in the future among other centers. Currently, arrangements are being finalized to effect the 24-hour service at the 3 health centers identified in the 2019 budget. Thank you again, Madam Speaker.
Supplemental member for Karen East.
Honourable Minister, what is your reason for closing down many of the health centers, not closing completely, but not allowing them to go to 9 p.m. when there were approximately 50 that were opened up to 9 p.m. Now, only 3 you're mentioning so far. What has happened to the other 40 plus?
Thank you very much. Thank you very much, Madam Speaker. Madam Speaker, it must be recognized that there are other district health facilities that operate on a 24-hour basis. For example, you have Princestown, 24 hours. Hoover, 24 hours. Chaguanas, 24 hours. St. James, 24 hours. Arima, 24 hours. And Siparia, 24 hours. And Mayaro, 24 hours. This is in addition to the A&Es at the major hospitals like San Fernando, Sangre Grande, Mount Hope, Port of Spain. So in looking at resource allocation, one has to make a decision. But there are ample facilities in addition to health centers, district health facilities, over 7, plus major hospitals open 24 hours a day to provide service. But Madam Speaker, let me just add one thing. And this is an issue all ministers of health have had to deal with, including my predecessor, who literally pulled his hair out over this issue. Our public in Trinidad and Tobago like to think that they must only go to a hospital A&E, when these health centers and district health facilities can more than adequately deal with many of the emergencies. So, not a Marabella. So, between these 7 district health facilities open for 24 hours, your major hospitals open for 24 hours, many of your health centers with extended hours up to 8 or 9, there is ample opportunity for people to access medical emergency services. Thank you very much, Madam Speaker.
Supplemental member for Barataria Sanwa.
I'd like to indicate health centers such as Maracas, Carenage, South areas where there are beach facilities. I noticed that the Sunday opening hours, would you consider opening those health centers on a Sunday based on the amount of the population that goes to these facilities?
Minister of Health.
That is certainly something that could be looked at, and I will give him the undertaking to look at it. Thank you very much, Madam Speaker.
Supplemental member for Karen East.
Sir, I heard your statement carefully. So is there any intention whatsoever to open some of these health centers close to the population up to 9 p.m. because the health centers you mentioned opening up to 24 hours are so sometimes quite remote from the normal population?
Minister of Health.
Madam Speaker, once the numbers and patient throughput could be justified, it is something we are prepared to look at. Thank you very much, Madam Speaker.
Member for Oropouche West.
Thank you, Madam Speaker. Question number 73 to the Attorney General.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, the first part of the question asks the reason for the delay in the return of the search of Principe from the probate registry. I'm able to say that there are now no delays in the return of the search of Principe from the probate registry. All searches can in fact now be completed within 3 days or less. This is based on the judiciary's launch of an e-probate service. I should add that was not supported by the opposition. On July 23, 2018, of the 2,627 search requests received electronically as of February 1st, 2019, 2,435 searches were completed. 155 were returned with errors, 37 are pending. Of the 2,435 completed, 98.5% of them were completed and returned to the requester within a 3-day period. That is the judiciary's stated turnaround policy, and they have kept to it. This period included holidays, I might add. The average number of days by which each of the other 1.5% of submitted searches were overdue is only 1.27 days. The second part of the question asked the reason for the inordinate delays in the issue of grants of representation of estates of deceased persons. Madam Speaker, at present, the main reasons for the sometimes longer than usual timeframes for the receipt of grants are, simply put, user inputs, the number of substantive and minor errors which create queries when information such as names, dates, and addresses are not consistent in the applications and related affidavits, the delays in submitting to the probate registry the required supplemental information required from applicants, and the loss of trained staff does in fact give us some degree of concern. Trained staff, if at full complement, in a time frame can achieve completion within 6 to 8 weeks if there's an error-free application submitted. Thank you.
Supplemental member for Oropouche West.
Attorney General, would you agree with me, or are you aware that queries are answered via supplemental affidavit? 6 to 8 months it takes for those queries to be checked, and then another 8 months for those same queries to be resent to the attorney to answer those queries.
Question.
So you're looking at 8 and 6,
Question,
14
member.
months. I'm asking if the Attorney General is aware of those supplemental affidavit that has to be answered.
Sure.
And the same queries returning.
Attorney General.
Madam Chair, it is for that very reason of the paper management that this government, in piloting the divisions of court that we did, and very importantly in piloting the court pay system, which was flatly refused by the UNC to allow for electronic systems and payments to happen. It is for that reason that we brought the legislation which has now resulted in things being done in 1 to 2 days. What I find infradig, most respectfully, is that there must, of course, be an acknowledgement that the archaic system is fraught with errors, the paper management system. This is why we have gone to an electronic platform. What I'd encourage the opposition to do is to support good measures.
Supplemental member for Oropouche West.
Attorney General, are you aware that some of the queries that are asked, for example, an applicant is 80 years old, the deceased, who is her father, is 95 years old, and one of the queries asked is for a paternity order. How is it that are we going to answer some of those things?
Attorney General.
Madam Chair, I hope that my learned colleague doesn't need to declare a conflict of interest in having a vested interest in matters, but I take the example for what it is. Obviously, that's what the law is there for. Minors have the ability to be represented via guardians ad litem, etc., and there are particulars for the answering things within the locus of the court. That's what the court is there for. So yes, there will be complexities as a result of extremities of age. In fact, an infant could be as young as 3 months old and be entitled to beneficial aspects. The point is, that's what the law is there for. Is the law as simple as it ought to be all the time? Certainly it's not, Madam Speaker. So those are matters to be worked out in the application of the circumstances of law onto facts.
Member for Oropouche West.
Thank you. Question number 74 to the Attorney General.
Attorney General.
Madam Speaker, the question relates to the Real Property Ordinance section of the Land Registry, and I've been asked to state the reasons why applications for loss grant and requests for duplicate certificates of title are supposedly taking approximately 3 years to be issued. Madam Speaker, I can say that this is a two-stage process. In the first stage, with respect to loss grant applications, the timeline for a loss grant application, it's set to be processed within 7 working days. The actual timeline where there are no queries is 5 to 7 days. If there are queries, it's 5 to 7 days from when the queries are answered. If there are no queries, then the attorney at law can proceed to the second stage. At the second stage, which is the issuance of the original duplicate certificate of title, currently that time frame for issuance is within 4 weeks. Madam Speaker, it should be noted that the timeframes are dependent upon factors, and these include the length of time the applicant, attorney at law, takes to answer a query, the length of time the applicant or attorney at law takes to collect the notice to publish in the daily newspaper, the length of time the applicant or attorney at law takes to publish the notice in the newspaper, the length of time it takes to register the request for the issuance of the new CT after publication of the notice, and the length of time the attorney at law takes to withdraw the certificate of title.
Supplemental, Member for Bucharest.
So why then electronic means is not also used in this probate in the registry to send the queries to the attorneys?
Absolutely. Brilliant question. I wonder if my learned colleague understands what she has just said. The reason is that there was no operationalization of the following things. One, the Electronic Transactions Act. Two, the Electronic Transactions Act rules as applied under the Audit and Exchequer rules of 2014 and 2015. Three, the failure of the last government to digitize the records that were in perspective. Madam Speaker, I am able to say today that coming into the office of the Registrar General as Minister of Legal Affairs, I met a system where none of the IT was up to date. The licenses were allowed to lapse. The building was crumbling. The towers where we have moved to on Richmond Street were empty for 9 full years. Since that time, we have actually digitized millions of records, Madam Speaker. And I'd like to say, we intend to go live with electronic payments as we ramp through in stages February 2019, March 2019, April 2019, so that people can have the dignity of having electronic transactions paid for and managed in a circumstance that the last government was incapable of delivering.
Supplemental, Member for St. Augustine.
Would the Honourable Attorney General indicate whether, in fact, in terms of the electronic payment, that substantial work had already been done to prepare that? And two, that in terms of the digitization of the records, that had been started and that there was international funding that had already been approved to deal with those issues, and that you inherited that foundation.
Madam Speaker, I wish to agree that work had been started when the member for Aruka Maloney was the Minister of Legal Affairs. And in fact, Madam Speaker, the digitization effort happened under her hand as Minister of Legal Affairs. What happened in the period 2010 to 2015, through no fault of the member for St. Augustine, was that the technocratic push for electronic transactions was not managed. The scanning of the real property ordinance files had begun. But Madam Speaker, the RPO titles represent under 25% of Trinidad and Tobago's title. It is the old law titles that represent the other 75%, which we have done in the millions. Secondly, Madam Speaker, we met the property business real estate solution package, the IT package, as merely something on paper. It took this government under Minister Hinds and my management with the Minister of National Security, then in that ministry, to execute the contract, put it into delivery, and I'm pleased to say that we are 2 months into a 12-month contract as we intend to make this reality for the first time.
Member for Orpooch West.
Madam Speaker, question number 75 to the Attorney General.
Attorney General.
Madam Speaker, I've been asked to state the reasons that certified copies of common law deeds at the land registry in San Fernando supposedly take 6 months to be issued to the purchaser. I'm able to say, Madam Speaker, that registered deeds are processed within 3 weeks, Madam Speaker. The scanning and data entry for deeds registered in San Fernando are done at the Port of Spain office because we're currently battling a limitation of space constraints in San Fernando, and certified copies of deeds which are already on the system are processed within 5 days.
Member for Faizabad.
Thank you, Madam Speaker. Question number 78 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, there is a 7 sluice gate structure which currently exists in the St. John Trace Avocat. 4 of these gates are non-functional. The Drainage Division under the Development Program has a dedicated program for the upgrade of pumps and gates called the Program of Upgrade to Existing drainage pumps, and gate inventory. This program was approved by Cabinet, and as part of the program, one of the projects earmarked for completion during fiscal 2018-2019 is the upgrade of the gate structure at St. John's. Madam Speaker, the objective of this project is to repair and motorize all 7 gates located in St. John Trace. The tender process is set to begin by mid-March 2019, following which the rehabilitation of these gates is scheduled to commence in June 2019. Thank you.
Member for Faizabad.
Thank you, Madam Speaker. Question number 79 to the Minister of Agriculture, Land and Fisheries.
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam Speaker. I'm not acting Minister of Agriculture, but this question has been redirected because of its nature to the Minister of Energy and Energy Industries. Madam Speaker, the Ministry of Energy and Energy Industries has written to the Fisheries Division of the Ministry of Agriculture, Lands and Fisheries, requesting a meeting with representatives of the Fisheries Division to discuss the logistical changes the fishermen may have to adopt in order to access fuel following the cessation of the supply of regular fluid, after which it is our intention to meet with the fishermen to discuss the outcome and chart a way forward as to addressing the grave situation that they face.
Supplemental member for Faizabad.
Thank you, Minister. Following a meeting with fishermen at the OTT fishing facility, the question was raised as to whether the government will consider providing a subsidy in that particular case. Is that something you would give consideration to, Minister?
Minister of Energy and Energy Industries.
Through you, Madam Speaker, that will fall into the laps of the Minister of Agriculture. But from the Ministry of Energy side, we have made it quite clear that it will be impossible to supply the market with regular, at least in the short term, until the refinery becomes operational, hopefully later this year or next year. And we will work out, if the Ministry of Agriculture is so inclined, we will work out the logistics of whether a subsidy could be paid or not.
Supplemental member for Faizabad.
Thank you, Minister. Minister, can you indicate what sort of time frame is anticipated before the fishermen can get a definitive answer on this matter?
Minister of Energy and Energy Industries.
We are looking at weeks. Weeks, yeah.
Member for Chaguanas West.
Thank you, Madam Speaker. Minister, have you contemplated, other than the subsidy, whether or not there are electric engines for the fishing industry to use instead of the fuel engines?
Minister of Energy and Energy Industries.
That has never been considered by the Ministry of Energy. I could probably inquire as to whether that technology is available and how useful is it.
Member for Faizabad.
Madam Speaker, question number 80 to the Minister of National Security.
Minister of National Security.
Thank you very much. Thank you very much, Madam Speaker. Madam Speaker, with respect to the seizure of the 23 rounds of Trinidad and Tobago Police Service issued ammunition along a Rima Old Road, Aruca, that matter is currently being investigated by the Professional Standards Bureau in the Trinidad and Tobago Police Service, and as such, they've asked that no further particulars be provided at this time.
Supplemental member for Faizabad.
Minister, following that incident, the Commissioner of Police announced that an audit will be undertaken into ammunition over the past 20 years. Can you give us an update on the status of that audit?
Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, the audit is ongoing. The Commissioner of Police has put in place certain resources to carry out that audit. As you would expect, the Trinidad and Tobago Police Service has quite a lot of arms and ammunition, so it's currently being undergone.
Supplemental member for Faizabad.
Thank you, Minister. Minister, in light of that incident, is there any assurance you can give the public as to steps that may have been taken in the interim to prevent that sort of incident happening again?
Minister of National Security.
Madam Speaker, the right person to give that assurance would be the Commissioner of Police. But what I can say is that after this incident, at a meeting with the heads of security, it was raised a serious concern Unfortunately, this is not the first time that this happened. So really it's for the armories to carry out proper audits to make sure that everyone who gets ammunition comes back in, accounts for it, etc. And we've made a renewed call for the police service, the officers in the police service, to make sure they take that very seriously.
Request for leave to move the adjournment of the House on definite matters of urgent public importance.
Member for Chaguanas West.
Thank you, Madam Speaker. Madam Speaker, I hereby seek your leave to move the adjournment of the House today under Standing Order 17 for the purpose of discussing a definite matter of urgent public importance, namely the failure of the Honorable Prime Minister to trigger Section 137 of the Constitution of the Republic of Trinidad and Tobago for the appointment of a tribunal to inquire into the conduct of the Chief Justice. Madam Speaker, the matter is definite because it centers on the issue of the rule of law and an impasse being showcased by allegations against the Chief Justice by the Law Association and others. The matter is urgent because it impacts on the image and public confidence in the judiciary of Trinidad and Tobago, as there is a strong public perception in the legal fraternity that the independence of the office of the Chief Justice had been severely compromised and exposed to external influences. The matter is of public importance because the Prime Minister has a constitutional duty to the public and the legal profession to take action to ensure allegations against the Chief Justice are investigated in accordance with the provisions of the Constitution. I so move, Madam Speaker.
Honourable members, I am not satisfied that this matter qualifies under this standing order. I advise that the member pursue this matter under Standing Order 16. Member for Princestown.
Thank you, Madam Speaker. Madam Speaker, I hereby seek your leave to move the adjournment of the House of Representatives today under Standing Order 17 for the purpose of discussing a definite matter of urgent public importance, namely the failure by the Ministry of Local Government and Rural Development to negotiate and finalize long-term contracts for the collection and disposal of garbage and waste services affecting the constituencies of Princestown, Naparima, Moruga Tableland, and San Fernando East. The matter is definite because it pertains to the current situation faced by the constituents of Princestown, Naparima, Moruga Tableland, and San Fernando East, who are being denied garbage disposal and waste collection services in their areas due to the absence of reliable service providers over the past few weeks. The matter is urgent because service providers who have been operating via month-to-month contracts with central government have refused to continue with this arrangement, and there is no contingency plan to provide any relief to constituents. The matter is of public importance because if this situation were to persist, the health and sanitation hazard that already is a threat will become a crisis that will affect the health and lives of the many citizens across these constituencies. I thank you, Madam Speaker.
Honourable members, I am not satisfied that this matter qualifies under this standing order. I advise that the member pursues this matter under Standing Order 16.
Statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills second reading.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move, as I appreciate the warm welcome, that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be now read a second time. Madam Speaker, the bill before us is deceivingly simple. It is a mere 4 clauses in length. The first clause is simply the short title. The second clause says that the Act means the Magistrates Protection Act, and it is clauses 3 and 4 spread across a few paragraphs only that seek to amend Sections 4 and Section 5 of the Magistrates Protection Act. Madam Speaker, despite the brevity of that approach, this is actually a very serious matter for our August House to consider, this matter having passed through and having received the approval of the Senate already. The Magistrates Protection Bill seeks to cause an amendment to the Magistrates Protection Act. That is Chapter 603 of the Laws of the Republic of Trinidad and Tobago, which was brought onto the books, the laws of Trinidad and Tobago, by Act number 34 of 1917. That is now 102 years ago. It was amended only once in history by Act number 45 of 1979, which is now 40 years ago. And this Magistrates Protection Act, in fact, was modeled after the Justice Protection Act of the United Kingdom, which was an act of the United Kingdom in the year 1848. So, Madam Speaker, there is antiquity in this purpose. There is reason which needs to be put onto the record, and there is a matrix into which we must actually consider the bill. So, Madam Speaker, suffice it to say, this bill is intended to address the significant issue of our criminal justice system. Crime is the #1 issue for most of our citizens. Crime is an issue which is without political boundary, without racial consideration, without our respective views on creed. It is something that affects us all. For those who feel that they have never been affected by crime, I'd say it hits you in your pocket, because the taxpayers of this country foot the bill as it relates to the management of the situation of crime. Madam Speaker, the issue of crime touches our constitutional rights set out in Section 4, which deal with the most basic provision of the right to life and freedom and liberty. So, Madam Speaker, year after year, decade after decade, governments have come to the Parliament and tweaked laws. They've amended the Firearms Act, they've amended the Kidnapping Act, they've amended the Sexual Offences Act, but very few governments have managed to get to the deep cause root reform of the criminal justice system. In our tenure, we have spent the first 3 years in particular of our time addressing the improvements to the criminal justice system. Very importantly, in our fight against crime and in our pursuit of white-collar crime or follow-the-money crime, and in our focus on money laundering as it is driven into reality from the predicate offenses of corruption, fraud, drug offenses, etc., trafficking in narcotics, what we have done is to harmonize a lot of our laws. We've taken what were previously indictable offenses only, we have brought them down to summary offenses or offenses triable either way. What does that mean? We've taken serious matters such as anti-gang matters, anti-terrorism matters, proceeds of crime matters, and we've converted them alongside matters in the Insurance Act, the Copyright Act, a number of different laws into summary offenses. With that in mind, Madam Speaker, it is important to remember that the persons who are charged with the responsibility of managing summary offenses are magistrates. Magistrates have the ability, if a charge is raised on a summary basis, to have a full determination of a matter and for it not to go to a higher court or the assizes if it is a triable either way or indictable offense, meaning you will have no high court jurisdiction. So, Madam Speaker, the first point is that our laws and our management of our system, the introduction of our criminal division as we brought on, the introduction of the criminal proceedings rules, all of these things have taken us to the point of looking at the security of the office of the magistrate holder. That's the aim of this bill, to improve the security of the office of a magistrate. So why do we need to do this? Surely people believe that magistrates are equivalent to judges. Surely people look to the fact that the common law protects judges as an ancient right of the common law. In fact, there's very useful dicta on that point that I'd like to put forward. And this comes from an interesting case decided July 13th, 1907. It's McCready versus Thompson, and it is a case which concerned analysis of liability of judges versus magistrates, etc. And I'd like to put onto the record the dicta of Lord Justice Clark delivered in that case. And Madam Speaker, here's what Lord Justice Clark had to say as it relates to the citation is, forgive me, I don't have the first page to give you the citation. I will give it to you. It is 1907 reports. I don't want to give you the wrong point as to whether it is Queen's Bench or All England, so permit me to get that for you. Here's what Lord Justice Clark had to say. Upon the question of immunity of judges of the Supreme Court, there can be no doubt. The principle is clear and the decisions are emphatic. The principle that such judges are the king's judges directly, bound to administer the law between his subjects and even between his subjects and himself. That's a very interesting dicta which was properly adopted in some of the leading cases in Trinidad and Tobago. In analyzing the protection which judges of the Supreme Court have, they being created by the section of our Constitution in recognized entrenched protected provisions, the point is that judges and the immunities of judges are firstly managed by the common law aspects of judicial immunity. And I thought it important to add to the McCready thinking or confirmation of law by reflecting upon the decision coming from Mr. Justice of Appeal Nolan Barrow in the case of Myrtle Crevel, Administratrix ad litem of the estate of Clyde Crevel versus the Attorney General. It is Civil Appeal number 45 of 2007. And in that judgment, there was proper reflection on two leading cases. I'm sure most of the attorneys present would be aware of Maraj versus the Attorney General. We call it Maraj number 2. That's 1978-30 West Indian reports at 310. And then, of course, there's the Independent Publishing Company Limited and others versus the Attorney General. That's a Privy Council decision, 2004, UK PC at 26. And what I want to put onto the record is that the Court of Appeal affirmed the dicta coming from Lord Diplock in Maraj number 2 in putting forward the reality that the claim for redress as brought against judges is a claim against the state for what has been done in exercise of judicial power of the state. This is not vicarious liability, it is the liability of the state itself. It is not a liability in tort at all. It is a liability in the public law of the state, not of the judge himself, which has been newly created by Section 6(1) and 2 of the Constitution. In looking at the independent publishing, it was noted that the Privy Council held in deciding whether an individual's right to liberty had been violated. It was the legal system as a whole which must be looked at and not merely part of it. And the reflections coming out of the Crevel case in upholding the dicta in the Maraj number 2 and in the publishing case affirm the fact that judges have an immunity which is, by common law standard, a general immunity because they are acting for the state itself. Magistrates, however, Madam Speaker, stand in a very different class. Magistrates are creatures of statute, Madam Speaker. Magistrates find their grounding in the Summary Courts Act, Chapter 420. If we turn to sections of that parent law, and we look starting with the definition section at Section 2, a clerk means a clerk of the peace. A magistrate includes a magistrate appointed on contract under Section 3B. But when we get to Section 3, there shall be such number of magistrates in the public service as may be required for the purposes of this Act. And every magistrate shall be ex officio a justice of the peace. Section 3A goes on to give you the qualifications for magistrates, attorneys at law in Trinidad and Tobago, practicing for not less than 5 years, etc., etc. So magistrates find their grounding in statute. And it is because they find their grounding in statute and that they are not in the situation of the king himself, as I've referred to in the McCready decision, magistrates are therefore confined to act within the statutory limits of their jurisdiction. It is there, Madam Speaker, that we must draw the line to look at the Magistrates Protection Act. The Magistrates Protection Act as a law itself is one that provides immunity in certain circumstances only. And that circumstance, Madam Speaker, begins to find grounding in sections 4, 5, etc., continuing right down to section 9 of that parent law. And effectively, it is sections 4 and 5 that we now come to measure. In section 4 and section 5, we find the limits of authority that a magistrate operates under. In section 4, we specifically say, Madam Speaker, this is the Magistrates Protection Act, Chapter 603. Section 4 says, the current law, the endorsement of the writ of summons in every such action shall allege either that the act was done maliciously and without reasonable and probable cause, or that it was done in a manner not within the jurisdiction of the magistrate. Otherwise, the writ shall be set aside on summons, and if the plaintiff fails at the trial to prove the allegation, the verdict shall be given for the defendant. Terminology has changed. We now have claim forms. We now have claimant versus plaintiff, etc. But what this law says is that you have a right of action against a magistrate in his personal capacity pursuant to section 4 of this parent law in two circumstances. If the magistrate acted maliciously and without reasonable or probable cause, or in the second category, that the magistrate acted outside of his jurisdiction, meaning did not comply with the strict provisions of any written law, Madam Speaker. Section 5 provides a limit, and that originally is that where an act is done without jurisdiction, malice need not be alleged, but no action shall be brought until the conviction is quashed. So there was a form of a safeguard in Section 5. No need for malice, but you had to quash the thing upon which you were complaining, meaning a high court could have overturned it, or the court itself could have dealt with it. Section 6 to 13 of this short law treat with the other circumstances in which you can manage the magisterial exercise of jurisdiction in respect of warrant, in respect of arrest, where a magistrate is acting in the place of another magistrate on the return of a warrant or arrest, etc. In all of those circumstances, the various permutations and combinations are measured. But, Madam Speaker, it's a few other laws which articulate with this that must also be part of the parliamentary record. They include the Indictable Offences Preliminary Inquiry Act, because it is in that act, Madam Speaker, that we find the definition of the magistrate or justice. Remember, the Magistrates Protection Act treats with magistrates or justices. It is the Indictable Offences Preliminary Inquiry Act, Chapter 1201, Section 2, subsection 2, that defines justices as clerks of the peace. That is to be distinguished from the definition of clerk of the peace in the Interpretation Act, Chapter 301, Section 78, where that refers to a justice of the peace. So there is a distinction between magistrate and justice. Justice means clerk of the peace, not a regular justice of the peace. Importantly, the Criminal Division and Traffic Court Act, which is now law in Trinidad and Tobago, redefines the clerk of the peace to be the registrar of the magistrates court effectively, and we have now harmonized those terms. So the target of this legislation is to treat with immunities and obligations of the magistrate and what is now going to be the registrar of the magistracy, who is the clerk of the peace referred to in the older law. Why are we doing this? It's because the State Liability and Proceedings Act, Chapter 802, has a specific limitation. In Section 2 of that Act, the State Liability and Proceedings Act, we define an agent in relation to the state to include an independent contractor employed by the state, but does not include a statutory corporation, except where the state has entered into an express contract. And very importantly, in that same section, we define a servant. And in the definition of servant, servant in relation to the state etc., includes a minister of state, member of the armed forces of the state, member of the Trinidad and Tobago Police Service, but does not include the president, any judge, magistrate, justice of the peace, or judicial officer, any officer, employee, or servant of a statutory corporation. Because, Madam Speaker, Section 4 of the State Liability and Proceedings Act is the section that says that the state shall have liability in tort for its agents or servants. What does that mean? Prior to the amendment in English law, you couldn't sue the state in tort, meaning you couldn't get damages for things that were done wrong. The English law came about in the 1800s, effectively to amend that position to allow for damages to be applied against the state. Our version of the State Liability and Proceedings Act, which is an Act of Parliament number 17 of 1966, that says the state will pay damages in negligence, in tort, etc., for people that are its agents or servants, but we say the servant could never be judge or magistrate. When you now look to the immunities that I started off with for a judge, the judge is covered. That's why I read McCready, that's why I referred to Mirage number 2, that's why I referred to the publishing cases. That's why I referred to the common law and the umpteen texts that give us guidance, and commendably so that from Dana Sitahal, as we've all read. That is to lay the groundwork now in terms of proportionality to say that this bill must treat with a lacuna. The lacuna in the law is that the magistrate is left in the lurch. We have established as a matter of fact that the magistrates are now in modern Trinidad and Tobago subjected to the obligation to apply the law in very serious circumstances for the summary offenses, for the multiple amendments that we've made. But, Madam Speaker, it was brought home to the fore, I think most clearly, in litigation and by way of correspondence coming to the attention of the Office of the Attorney General. Madam Speaker, in the case of Indar Jagru versus Anisha Mason, and that is two particular judgments that I'd like to refer to. There's the High Court decision of the Honorable Mr. Justice Peter Rajkumar, as he then was. He's now Justice of Appeal. And his decision was given on the 23rd of May, 2014. And then there's the Court of Appeal version of that case, which is Civil Appeal number P182 of 2014. And there's the judgment that was delivered, Madam Speaker, by the Honorable Mr. Justice Narain, Justice of Appeal, who gave the decision on behalf of the majority. And Madam Speaker, I want to put onto the record the fact that both courts reflected upon a very important need. In the circumstances of that Jagru case, basically, the magistrate was invited to consider a fit persons order or beyond control order within the context of sections 44 and 45 of the Children's Act, as it was then unamended. The magistrate put a minor who was declared to be 17 years old into the women's prison, even though she was not charged. In the interrogation before the courts were clear that there was no malice, that the magistrate acted in the best interest of the child, but the court found it an irrefutable thing that the magistrate acted outside of the statute, which is the Children's Act. And the magistrate had no jurisdiction to put the child into the women's prison, because the child was not somebody apparently at ages 14 or 15 that could have fit into a different category. The Court of Appeal went on to agree completely with Mr. Justice Peter Rajkumar's decision, and the Court of Appeal said this at paragraph 28, which I wish to put onto the record. After holding that the judge had acted, the magistrate had acted with bona fides, with no malice, in the best interest of the child, after finding that the magistrate had acted outside of the statutory provision of authority, the court went on to say this at paragraph 28. It follows that we found no merit in the appeal. The appeal was that of the magistrate. However, we must express our concern for the position in which a magistrate is held personally liable for his actions while presiding on the bench, in a situation where he has acted without or in excess of jurisdiction but without malice of any kind. The injustice that may arise in such a case and the need for legislative intervention was recognized by the House of Lords in McSee versus Mullen, which is 1984, 3 All England Law Reports. And they went on to quote dicta from Lord Justice Templeman, which I think is extremely relevant for today's purpose and which I wish to put on the record with your leave. Again, quoting from paragraph 28 of the Court of Appeal judgment. And these are the words of Lord Templeman, who opined at page 29, 929 as follows. This appeal demonstrates that the time is ripe for the legislature to reconsider the liability of a magistrate and the rights of a defendant if an unlawful sentence results in imprisonment. There is no liability on a judge of the High Court acting as such, and no right for the defendant to damages for an unlawful sentence imposed by a High Court judge. Harm may be prevented or cut short by bail or an appeal procedure which results in the sentencing being quashed. The judge goes on to say, on the other hand, a magistrate is personally liable where an innocent error of law or fact results in an unlawful sentence or imprisonment imposed without jurisdiction. A magistrate is not personally liable for an innocent error of law or fact which results in an unlawful sentence or imprisonment within jurisdiction. I've referred to that particular dicta, Madam Speaker, in the judgment appearing in the 1984 All England Law Reports because they fit the exact circumstances of our debate today. Now, Madam Speaker, this actually came, this issue of jurisdiction, this issue of lack of immunity and protection came to the attention of the predecessor government. In particular, they came to the attention of Attorney General Ram Logan as he sat there. And I had confirmation of this position by way of letter from Alam Chambers under the hand of Rajiv Prasad, who wrote to me almost a year ago on Monday, the 19th February 2018, effectively asking for a written indemnity to cover Magistrate Indar Jagru. And the letter, with your permission, addressed to me, if I may quote portions of that, says, Senior Counsel Mr. Sinath Jairam and I have been briefed by the good office of the Solicitor General to represent His Worship Mr. Indar Jagru, the defendant in the caption. Magistrate Jagru has been sued in his capacity as presiding magistrate for the Arima Magistrates Court for having committed the claimant to prison, etc. The matter is now before the Court of Appeal. We had written to your predecessor seeking to have a decision made in relation to the provision of an indemnity to protect the learned magistrate. To date, we have not had a response, and we have been advised by those instructing us that another letter should be prepared and directed to your office, renewing our request on behalf of our client. I can tell you, Madam Speaker, that I indicated to Council that the indemnity was guaranteed and that I would move immediately to the Parliament to put parent law into effect, to amend the parent law to give that immunity to the magistrate, and therefore, standing in the House of Representatives as I do today, on the 15th of February 2019, it is to keep an undertaking given to a magistrate who is exposed to indemnity, who is requesting indemnity as he was exposed to personal liability, the court having in fact found that he was personally liable in the circumstances of acting without malice but without jurisdiction. So, Madam Speaker, it is important to bear in mind that the magistracy is having a careful look at what we do. The magistracy is being called upon to exercise greater jurisdiction. The magistracy is being asked to intervene in the affairs of our citizens of this country in a very important way, and that is something which we must hold dear. There's one last case that I'd like to bring to the attention of the Honourable House, Madam Speaker, through you, and that's the case of Siros versus Moore. It's 1972, Court of Appeal. It is S number 1660. It is the dicta of Lord Denning, Master of the Rolls, and it concerns an action not being maintainable where judge acting judicially in good faith. But it is the dicta of Denning, MR, at page 136 that I think is really very relevant to the Honourable House, Madam Speaker. Madam Speaker, this helps us under the caption, if I may, as I quote from page 136. It's under the caption, the modern courts. In the old days, as I've said, there was a sharp distinction between the inferior courts and the superior courts. Whatever may have been the reason for this distinction, it is no longer valid. There has been no case on this subject for the last 100 years at least, and during this time our judicial system has changed out of all knowledge. So great is the challenge, it is now appropriate for us to reconsider the principles which should be applied to judicial acts. In this new age, I would like, on my stand, to say this. As a matter of principle, the judges of Superior Court have no greater claim to immunity than the judges of the lower court. Every judge of the courts of this land, from the highest to the lowest, should be protected to the same degree and liable to the same degree. If the reason underlying this immunity is to ensure that they may be free in thought and independent in judgment, it applies to every judge, whatever his rank. Each should be protected from liability to damages when he's acting judicially. And the judge goes on, etc. And he ends by saying this. This principle should cover the injustices of the peace and this principle should cover the justices of the peace also. They should no longer be subject to the strokes of the rod or spur. Aided by their clerks, they do their work with the highest degree of responsibility and competence to the satisfaction of the entire community. They should have the same protection as other judges. Madam Speaker, these are words in 1975, 47 years ago, coming from Master of the Rolls, Lord Denning, and they are absolutely appropriate to the circumstance in Trinidad and Tobago today. So, Madam Speaker, that's some of the rationale, that's some of the depth, that's the comparison between the judges having immunity, the magistrates not having immunity, the clerks of the peace, as they are now registrars and clerks of the court pursuant to the criminal arrangements that we've done in the criminal division, etc., coming to the fore. But, Madam Speaker, if we look to the terms of the bill before us, I'd like to say that the bill really helps us because we are now providing, firstly, for a simplification, secondly, a clarification that we don't oust by way of implied repeal certain other remedies available to litigants, and then we are harmonizing the parity between the judges of the Supreme Court and the judges of the inferior court, or the puny judges as they, or the magistrates and masters when exercising that jurisdiction under the criminal division. So, Clause 3 of the bill, which repeals Section 4 of the Act, replaces it with the following. 4.1 now says, no action shall be brought against a magistrate for any act done by him in the execution of his office in relation to a matter within his jurisdiction. Subsection 2 says, nothing in subsection 1 shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, including appeals, applications for judicial review, and applications for redress under Section 14 of the Constitution. What does that mean? First part is pellucidly clear. It harmonizes the rules and functions which we have for judges of the High Court with the magistrates and clerks of the peace. But the second part was really taken from the text of the laws of Bermuda, the Magistrates Act 1948, which said in their Section 10A subclause 2, nothing in subsection 1 shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, including appeals, applications for judicial review, and applications for redress under Section 15 of the Bermuda Constitution. Now, we felt in the original version of this law that there was no need to state that, largely because the UK legislation, Courts Act 2003, and umpteen other jurisdictions, Jamaica, New Zealand, etc., have a similar provision to ours, where they had judicial review legislation and constitutional Section 14 rights similar to ours prior to the Act. And there was enough dicta to say that, look, that law would not be disturbed. But we listened to voices in the Senate, having recognized that it was debatable either way, and put in the language from the Bermuda Magistrates Court Act to make sure that the law was in no need of challenge for clarity or statutory interpretation. The second part of the law, which we treat with, is the amendment to Section 5, and this is treated with by Clause 4. We amend the marginal note. We remove the need for malice not being alleged, and we simply put a new subsection 5.1, leaving 5.2 as it is. 5.1 now says, a person may maintain an action against a magistrate for any act done in a matter not within his jurisdiction or in excess of his jurisdiction, where it is alleged and proved that the act was done maliciously and without reasonable and probable cause. So, Madam Speaker, the aim of the law is stated. The proportionality of the law is as relevant today as it was 47 years ago in the United Kingdom, as per the dicta in the Cyrus decision by the Master of the Rules, Denning, in that circumstance. It's as relevant as Lord Diplock's decision in McCready. It's as relevant, in McSee versus Mullen. It's as relevant as Lord Templeman in 1907 in the McCready case. And Madam Speaker, it is particularly relevant in Trinidad and Tobago because of the harmonization of jurisdictions that we have achieved under the criminal division positions. It is particularly necessary if you are going to invite magistrates to act robustly and without fear of action or intimidation by suit which may come against them, that they be provided with the form of indemnity that the judges of the High Court enjoy. Madam Speaker, I look forward to contributions of my learned colleagues, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be now read a second time. Member for St. Augustine.
I thank you very much, Madam Speaker. The Attorney General, in his very articulate way, opened by saying that this law is deceivingly simple. I think he misspoke. I want to suggest that this law is simply deceiving. Let me explain why. If it is that the purpose of the amendment and the change of the status quo is to give protection, immunity to magistrates, then it's a far simpler thing to do than to what we have now before us. But lady, with all due respect, I am not going to be long, but please do not measure the importance of what I'm about to say by the shortness of my presentation. What the Attorney General, and I hope unintentionally, is doing here is making it near nigh impossible for citizens to be able to take action against magistrates. Because what they have introduced here now is a positive need for malice to be alleged and for malice to be proven. What is malice? The simple English dictionary meaning is to cause pain, injury, or distress to another, or to do something with an intent to commit an unlawful act or cause harm without legal justification or excuse. But in our law, there's something called malicious prosecution. And malice has not been properly identified or defined. It is really dependent upon the factual circumstances of every case that a court may find or not find that malice attended to the actions or inactions of one of our citizens, whether they're a judicial officer, a police officer, or anybody exercising administrative or authority, executive authority. If I may, and I know the Attorney General is familiar with this case, it's a matter of Trevor Williamson and the Attorney General. It's reported as Privy Council Appeal number 0039 of 2012. And there, the matter of malice was discussed in relation to malicious prosecution. And it will help a little bit to shed light where this judgment being delivered by Lord Kerr said this at page 3, paragraph 11. In order to make out a claim for malicious prosecution, it must be shown, among other things, that the prosecutor lacked reasonable and probable cause for the prosecution and that he was actuated by malice. These particular elements constitute, and I want you to pay particular notice, Madam Speaker, significant challenge by way of proof. It has to be shown that there was no reasonable proposition, normally amongst the most difficult of evidential requirements. Let me repeat that. This requires the proof of a negative proposition, normally among the most difficult of evidential requirements. Secondly, malice must be established. A good working definition of what is required for proof of malice is in the criminal context is to be found in the authority of A versus NSW. And he went on to reflect on that, quoting, "What is clear is that to constitute malice, the dominant purpose of the prosecutor must be a purpose other than the proper invocation of the criminal law, an legitimate or oblique motive. That improper purpose must be the sole or dominant purpose actuating the prosecutor." It is known to almost every school child, and most of us here imagine, that statement, not even the devil knoweth the mind of a man. And that proposition is found in support in even the Bible at Kings 8:39. What this means is that you, a person who feels aggrieved, must prove, you must allege that the magistrate acted with malice. And you must be able to prove it. How can one ever possibly do that? Unless, of course, the magistrate is so reckless and allowed to fall from his or her lips that you see you, I'm going to bust a jail on you that you will never, ever imagine you could have got. Whatever the offense, you come back before me, no bail, or something like that. Actual words, hardly actions, because the magistrate sits there in judgment. How can you prove the malice? Milady, let me give you an example of something that really occurred. Years ago, a magistrate sitting in Arima, there was a matter I was involved in, and I make full disclosure up front. And for whatever reason, that magistrate took an action that we thought was wrong in law. And we filed for judicial review. And I want to say before then, the relationship was one of mutual respect between the court and myself. But when we took judicial review, there was a change in attitude and tone from this magistrate. We're all human. We are all very human. And I could understand. There was no intent, of course, for personal liability and that sort of thing, but really a way to vindicate what we considered a wrong. Some years after, this magistrate moved to another jurisdiction. And a relative of mine had a business that included a bar. And he had died. His grandson wished to have the liquor license transferred into his name. What we would have considered a very easy, simple, non-complicated issue. Every time that matter came before that magistrate, and he carried my surname, there would be a request for something new. If it wasn't town and country plans, some amendment, some fire issue, and it went on for 2 years, the effect of which was that the business was killed. No, I can't say there was malice. I cannot prove it, but I know what I feel. If there was an action to be brought, what could you say? The magistrate was acting within jurisdiction for asking for these things. And this thing about jurisdiction means authority and power. That's simply what it is. But you know something has gone terribly wrong. How can you prove malice? And I want to make another disclosure. I am very keen on this issue of indemnity, Attorney General. What is not known to the general public in the middle of the year 2015, with an election imminent, the good Prime Minister of the day, Kamla Persad Bissessar, had made me, had appointed me to be the Minister of Justice. And under that purview were the prisons. Yes. And what happened as a big surprise and shock, that when I went into that ministry, we realized there was a need for immediate mitigation of some of the health and OSHA issues. We put together a committee. Nobody asked. We did this on our own volition in the ministry. Put the president of the Prison Officers Association as a member of that committee to move forward with urgency to repair things that, that had not been done as a, in terms of ventilation and other safety issues. A lot of work had already been done in terms of creating alternative prisons. You might recall the center that was purchased as a decanting center, first of all, and plans were well afoot for the building of new cell blocks within the prison. But in the old prison, there was an immediate need. So we decided to put this committee together, and the committee met on several occasions, and the one person who never really turned up or helped was the president of the Prison Officers Association. But to my shock and dismay, member for Laventille West, you know how it is, I got served that I am now charged with an OSHA breach. I was told that I could go to jail for this thing, the irony of which is for the very prisons that we had control over, if I'm found guilty. We went to the industrial court. The matter was dismissed summarily because there was a breach in the process and procedure. I thought that was the end of it. Just around election day, I'm served again. They relayed the very charge. The matter came up before the industrial court, dismissed only last December. I understand now there's an appeal. But this time, the original players, I understand, were myself, the permanent secretary, and the commissioner of prisons. I understand I'm now the only
Madam
person.
Speaker, Standing Order 48-1, please.
So, Member for St. Augustine, if you could quickly tie your story into, I think, what was your original premise, please.
It is the most relevant of statement I'm making. That, that officers of the state do need indemnity and protection.
Yes.
And I understand probably the sensitivity of my learned friend, because I was about to make the point that apparently the only person against whom they have appealed is me. The irony of which is that not the, and my friend from the President Minister of National Security, who now has the remit of the control of the prison, he was never sued. Nor the former minister, how many he had? 4 or 5 of them? Not, whatever they are. Not a single one of them had been sued, but I was singled out. And I carry this burden still before the Court of Appeal. And I want to congratulate the lawyers from the Ministry of the Attorney General, junior lawyers, but very capable lawyers, who have done human service to that end to vindicate. Because it's not about Prakash Ramadhar, it's really about an officer of the state doing his duty and becoming vulnerable and possibly liable. So I make that point to show you that there is a real need to crystallize who are protected in what form or fashion. I did nothing wrong, I could say here, but I'm before the courts on that. The point at the end of the day, if it is that we are afraid that magistrates could fall into error and that you can possibly sue them and succeed because there's still judicial review and constitutional motions that are available, then who and what are we really protecting? It is a simple matter with tremendous gravity for the Attorney General to move an amendment to the law that protects all of the state agents, with, of course, some exceptions, and expand it, the State Liability and Proceedings Act, Attorney General. Why don't we go there and say, for whatever reason, if a magistrate or any judicial officer or former minister who is apparently still protected under that act does anything outside of their jurisdiction or whatever, that the state becomes liable. So that you will avoid now the ignominy of a person having to sue. And I understand, Attorney General, nobody wants a magistrate to become personally liable. And for several reasons, one of which is obvious, that they will be afraid, and as Lord Denning had put it, they should not, when they are administering their courts, be turning their pages with trembling fingers, afraid that their decision would lead to some action being taken against them, and therefore they cannot live up to their oath to do good and to do their duty without fear, because they will act under fear. So you are pushing at an open door in terms of protecting judicial officers in the exercise of their duty. But you're pushing the door in the wrong direction. Because, let me explain why. And it goes back now to who are magistrates. First of all, let me just say I know Mr. Jagru for a long time. As a practitioner, first-rate human being, an excellent lawyer, and a magistrate with a demeanor that is really to be admired and replicated. And for whatever reasons he got into problems, it is because he thought he was doing the right thing. And Attorney General, I congratulate you if you have actually given indemnity. I'm delighted to hear that. But I would like to ask you, in all this melee and so, is there any number that you could point to us or example as to who or how many magistrates have actually had to pay personally? Because I really don't know if there's any. Because responsible attorney generals generally will give the indemnity. But it shouldn't be left up to the decision of any one attorney general. I agree with you. And if it is that we are to give judicial officers protection, like judges, and as you have indicated, the judges were given that protection because they were seen as a king's own, and that the magistrates were differentiated because they are creatures of statute. But there's another thing equally, that judges have something called inherent jurisdiction. In other words, you cannot find their powers limited within any law book. They can give justice in any cause by their own conscience, what they think is right, and therefore they can go outside of what is expected or what is normal to give justice. So it is a simple fix, Attorney General, to deal with that issue by expanding State Liability and Proceedings Act. It is as simple as that. But what you have done, or attempting to do here, is really restrict the rights of citizens to take action against officers who hold power over their lives. A magistrate today and a judge has tremendous power because they can determine the fate of your future, whether you go to jail or you go free. Now to put a restriction on our citizens is a retrograde, undemocratic effort. Why is it we wish to protect the judiciary without enhancing the ability of our citizens to be protected? But I had cause to reflect upon it. And it is in a way part of the DNA of the party to which you belong. We got independence many years ago. But when we got independence as a people, there was a belief now that we have our local leaders who will determine our destiny, and they would look after the interests of all of our society. What we had then was an exchange from the colonialists to the neo-colonialists. A change of face and really, but no real change of the way we empower our people. In fact, 1970 had to be a wake-up call to the democracy, where men like Macandal Daga had to force social change. But now, here we are in the year 2019, this government once again, and there's a long history of replete with efforts to suppress our citizens, a pushback of rights. And this is the most glaring of examples. And when I said that this law is simply deceiving, I mean it. Because it gives a noble impression that we are to protect our judicial officers so that they can be fearless in the administration of their functions. Of course we want that. Yes. But the method by which you use to achieve it is creating more harm than the good that it will. Madam Speaker, there is before us a very simple decision. Whether this side will support Section 5 amendment more than anything else. Because the malice that we have spoken about, where you now have to prove, and I was actually the Privy Council 2 years ago, where we were trying to change the law a bit from malice to recklessness to a point where you will infer the malice from the recklessness, and the Privy Council was not ready at that point in time to go that route. In malicious prosecutions, it is easier to show by the actions of police officers that you can infer malice from it. But to infer malice, or to prove, not just infer, but to prove malice, really is putting up an almost insurmountable impediment to accessing the courts on these matters. So I ask the Attorney General to reconsider, because this is really a piecemeal approach. Because as the Attorney General has indicated, and we all know, there are many other functionaries now being brought into the judicial biosphere that would require protection. And to do this piecemeal bit, to deal only with magistrates at this point in time, when you could expand the State Liability Proceedings Act, really would be not doing service when it is readily at hand to have a fix and an answer to all of these problems. Let me give an example as to how a terrible injustice could be meted out. And we go back now equally to the appointment of magistrates. All you need, 5 years of practice. What our experience have been in this country is that there are young lawyers who, straight out of law school, apply to the DPP's department and they do yeoman service there. And the moment they reach that 5-year mark, it is their ambition, because of the workload and the terrible conditions some of them have to endure, to ascend to the magistracy, and they apply there. And many of them are chosen. I do not wish to go now into the low level of salaries that they may have received for those 5 years. But the moment they become magistrates, they become vulnerable unless we protect them. And you may have a magistrate making an error, and a matter is proceeded with where damages and costs are awarded against the magistrate, and an Attorney General takes a position that I'm not going to indemnify you. That magistrate may not even have the assets, home, car, or whatever, to sell to be able to deal or to pay for the damages and to pay for the costs. So on that point alone, an injustice could be had in relation to a citizen, because that magistrate could have acted with pure malice, could have made the threats I referred to earlier and do the things awfully to injure that person's rights, and the Attorney General could readily say, no, in the circumstances, I'm not going to give you an indemnity. And then the citizen now has no recourse, because the magistrate himself or herself would not have the asset base to liquidate, to pay these things. So there is a real need, but please don't put it in the way you have. Because the real intent and purpose of this, if you want to take a different point of view, is that this has little to do with protecting the magistrates, but it has everything to do with restricting rights. So, Madam Speaker, I've heard the Attorney General, and a simple amendment either to the State Liability and Proceedings Act could deal with this, or, as one of my colleagues would have made a suggestion in another place, that all damages or costs can be apportioned to the state from the consolidated fund to be paid, which is not really much of a difference if it is that is the real mischief that we want to deal with. So, Madam Speaker, I'm not going to detain you much longer, except it's to say that we have an easy fix, and the Attorney General put a very colorful thing into the population, colorful statement 2 days ago where he spoke about discussing water whatever. All I will say here, if you want to put out the fire, he has come without a fire engine. He has come without water. He has not come with a proper solution. All he has come with is an empty hose, right? To give the impression that they're dealing with something when, in fact, the answer and the solution is readily at hand. And I'm sure all of my colleagues will support a meaningful way, but a meaningful way that does not mitigate and take away some of the rights of our citizens. So I thank you very much.
Member for Chaguanas West.
Thank you, Madam Speaker. I'm a bit taken back that no one rose to support the Attorney General on that side with respect to this matter. Madam Speaker, the Attorney General, in promising simplification, clarification, and harmonizing parity, he ran up like Michael Holding, if I were to use a cricketing metaphor. But when you look at the content of the amendment, he really delivered like Uton Dow. Madam Speaker, this issue really deals with the functioning of the magistracy, and it really deals with, and I will start with the oath of the magistracy, of the magistrate, and then move on to link that with the issue of the independence of the judiciary. And I will demonstrate that in order to protect the independence of the judiciary, this amendment does not go far in accordance with the Constitution of this country. And then I am very familiar with the authorities indicated by the Honorable Attorney General, Madam Speaker, and I will go into them in some bit. Madam Speaker, the magistrate, in taking an oath upon his appointment by the Judicial and Legal Services Commission, and the Honorable Attorney General indicated the qualifications for appointment, takes this oath. I, having been appointed a magistrate, do swear or solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago and will uphold the Constitution and the law, and that I will conscientiously, impartially, and to the best of my knowledge, judgment, and ability, discharge the functions of my office and do right to all manner of people after the laws and usages of Trinidad and Tobago without fear or favor, affection, or ill will. So the magistrate, by taking this oath, promises to be an impartial arbiter, an independent, impartial arbiter, and a protector of the rights of the people. Madam Speaker, so this issue, and when you look at the legislation, Madam Speaker, and you look at what the extent of the work that is required of a magistrate, you understand that the magistrate, in fact, when you look at the Improving Court Services through Process Reform Annual Report of the Judiciary, 2017 to 2018, they point to, Madam Speaker, over 165,154 matters filed in the period 2017-2018. And it goes on to give you an extent and a breakdown of the matters. The Honorable Attorney General also indicated that there are grave matters now before the magistracy, anti-terrorism laws, you have the proceeds of crime, you have the copyright, the data protection, and a series of heavy legislation before the magistrate. So, Madam Speaker, tremendous workload. The magistracy is really the marketplace for justice in this country. And when you see the dispensation of that justice and the extent of the workload of each magistrate, Madam Speaker, I think it is in the other place, the Honorable Attorney General indicated that capital offenses, 168, domestic violence, 8,332, petty civil, 1,350, Private summary matters, 8,242. Ejectment, 772. Inquest, 797. Non-capital offenses, 28,186. Family matters, 14,535. Traffic, of course, 102,875. And then he went on, as the report indicated, the disposition rates and so on, Madam Speaker. So in today's world, the magistrate is really the workhorse in the judiciary. It's the workhorse. And when you go into your constituency and you have to deal with matters, you really see the dispensation of justice to the poor and downtrodden in our society. So when you have that kind of appreciation of the workload of the magistrate, Madam Speaker, I cannot understand why the Attorney General, as he indicated, after 102 years, seeking to bring an amendment to this legislation, sought to chinks. This is not a time for chinksing after a century. This is a time for opening up your bat and hitting the ball to the boundary. So what is required, Madam Speaker? What is required that the Attorney General, as he quote the various cases, should have seen that there ought to be no distinction whatsoever between the immunity provided to the superior courts of record and the magistracy in Trinidad and Tobago. Madam Speaker, so the relevant issue for us in this parliament today is how do you reconcile the personal liability of the magistrates for actions done in their judicial capacity with the core democratic concept of judicial independence and judicial accountability. So you have personal liability for a magistrate, personally liable in the exercise of his function, and how do you reconcile that with the concept of judicial independence? Freedom from influence. The Attorney General, by his own words, indicated that he gave an indemnity to Magistrate Jagru. And that is because the magistrate, both the High Court and the Court of Appeal, found him guilty of exceeding his jurisdiction, notwithstanding that he felt there was no malice, that he could not have gone out there and found an allocation for the young lady, 17-year-old, because the law under Section 45 of the Children's Act at that time only provided for 14 and 15-year-olds, apparently 14 and 15-year-olds. So that therefore, it must not be left to the discretion of an Attorney General to cherry-pick and determine which magistrates he assists. Never. And I want to really congratulate the Attorney General for doing the right thing. Because in the absence of malice, Madam Speaker, there is a presumption of regularity in the acts of public officials. And I want to really congratulate the Attorney General for taking that kind of decision. But I think that we need to go further. We need to go further because we have to understand that you cannot, as a matter of course, engage the magistracy, give them that workload to function, and not provide them with the necessary cover of indemnity, Madam Speaker. Madam Speaker, when you look at the Latimer House Principles, which is a publication of a guide for the magistrate in the Commonwealth, fundamental principles and recommended practices. Madam Speaker, when you look at the Latimer Principles, this is what they have to say at page 4, Madam, at item 1.2. Aspects of judicial independence enshrined in the Latimer House Principles and Guidelines. The Latimer House Principles and Guidelines support two fundamental principles: the rule of law and judicial independence. Although a difficult notion to define,
The rule of law is seen as the antithesis of the exercise of arbitrary power and entails the equal subjection of all classes to the ordinary law of the land administered by the ordinary courts. The twin notions of non-arbitrariness and equality before the law have a direct relationship with the concept of judicial independence. If the governed and the governors are to stand equally before the law, it is imperative that the judiciary should be impartial and have the appearance of impartiality. As an impartial judiciary is not possible without a truly independent judiciary, judicial independence is fundamental to the effective operation of the rule of law. So, Madam Speaker, you have that reality, but yet at the same time, in the exercise of his functions, the magistrate is exposed for personal liability in certain matters. So our argument today, Madam Speaker, is that all the authorities quoted by the Honorable Attorney General, Cyrus and Moore, and before that, he quoted Jagru, and Lord Templeman in Jagru quoted by Justice Rajendra Narayan in that matter, pointing for the role of the legislator to correct this anomaly. Because what currently happens is that notwithstanding the fact that the magistracy is part of the judiciary, you have a dichotomy. In fact, Madam Speaker, I would go so far as to say you have a caste system in which the magistrate is at the lower end of the caste, and the High Court judges of superior record are at the other end of the caste, at the higher end of the caste system. And in order to, you don't know, no. Madam Speaker, I'm speaking to you. So you have a caste system. And when you look as how this emerged, Madam Speaker, we're looking at a colonial system. 101 years ago, Marxism has not yet arrived, in which workers of the world unite. You have nothing to lose but your chains. You did not have that egalitarian universal principle. Egalitarian principle and universalism, Madam Speaker. So that therefore you had a class component. That is why the English, we inherit this from English, and the AG was right. Honorable Attorney General was right. 1848 law come down here in 1917. 1848 was the year of the revolutions in Europe. So that in this context, Madam Speaker, in this context, and I want to say that, so the variation between a superior court of record has been justified by the jurisdiction of these courts. A superior court jurisdiction is not limited by either person, place, or subject matter. I think my colleague, the member for St. Augustine, pointed out of the inherent jurisdiction of the High Court and is the superior court of record. But Madam Speaker, it is said that this jurisdictional issue between the inferior court and the superior court, it is unconvincing. And it was rejected by the Court of Appeal and quoted by the Honorable Attorney General in Cyrus versus Moore. The 1975 one Queen's Bench at page 132, and he already indicated that, Madam Speaker, and I want to re-quote, because I'm going to use it in a different context. Lord Denning, every judge of the courts of this land, from the highest to the lowest, should be protected to the same degree and liable to the same degree. If the reason underlying this immunity is to ensure that they may be free in thought and independent in judgment, it applies to every judge, whatever his rank. Each should be able to do his work in complete independence, free from fear. he should not have to turn the pages of his books with trembling fingers, asking himself, if I do this, shall I be liable in damages? So long as he does his work in the honest belief that it is within his jurisdiction, then he is not liable to an action. So that, and then they go on, Lord Bridges, Madam Speaker, suggested that the distinction between senior and inferior courts was, in respect of judicial immunity, was so deeply rooted in our law that it cannot be eradicated by the Court of Appeal, and probably not by your Lordship's House, since so fundamental a change would require appropriate legislation. That is why, with JAGRU, JAGRU was the trigger. That's why we're here today. That was the trigger. But there's a larger catalyst taking place in the outside this environment, Madam Speaker. In New Zealand, they accepted this common law position. Canada did not accept it. New Zealand accepted this position. So, but when the Honorable Attorney General, creating through the criminal division legislation, creating all the various offices, are you going to now still have this dichotomous immunity system in place and continuing the caste system from our colonial masters that we inherited? Madam Speaker, so you have that situation taking place. And when you look at that, Madam Speaker, you recognize that now there ought not to be any distinction. There is what is happening in Trinidad today at the level of the magistracy is called the JAGRU effect. Some good, some not so good. I am told, Madam Speaker, I'm advised, that a lot of the magistrates are now looking twice before they engage in meting out justice. And that is a good thing, that they are able to look twice. But the question is that looking twice now, there's an element of fear emerging. An element of fear has emerged, and that is the JAGRU effect. That the magistrates are now fearing that they may be personally become liable in matters if they exceed their jurisdiction. So, Madam Speaker, in a Jamaican case, High Court claim number 2013 HCV 05366, Brenton Henry the claimant, Honor Mrs. D. Gallimore Rose, first defendant, the Attorney General of Jamaica, second defendant. The authorities quoted by the Honorable Attorney General, Maraj number 2, you have the other matters. What you have there, Madam Speaker, is that right next door in Jamaica, you have had a change in the law, that there is no distinction now between the magistrate and the Court of Superior Record. So MC McMullen at page, and I want to quote from page 13 of this judgment, Madam Speaker, paragraph 40. It is to be noted that Parliament has now placed this issue of personal liability of resident magistrates, now judges of the parish. Now, when you look at our criminal division matter, Madam Speaker, we have a similar kind of nomenclature change taking place. So that when you have previously, you have now under the bill which will soon be proclaimed, I think it's 31st March, the Criminal Division and District Criminal and Traffic Courts Act. District Court judge means a magistrate referred to in Section 13. So you have a district court judge. What they have done in the Jamaican setting, they have now judges of the parish court. And I quote, Madam Speaker, It is to be noted that the Parliament has now placed this issue of personal liability of resident magistrates, now judges of the parish court, beyond dispute, since the passage of the Judicature, Resident Magistrate Amendment and Change of Name Act 2016, which came into operation on the 24th of February 2016. Section 7A of the Principal Act provides, judges of the parish court shall enjoy the same immunity from liability as judges of the Supreme Court. If Jamaica could do it, who is we? Who is we? And now that you trigger in the criminal division and you're creating district court judge, why don't you go? I'm tempted to say the whole hog, but I want to say, Madam Speaker, why don't you, in full sum protection of district judges in this country, magistrate meaning magistrate, Madam Speaker. So I think that you cannot allow this dichotomy to continue. And you are engaged in a system, Madam Speaker, and I try to fathom why the Honorable Attorney General embarked on this, this enterprise of chinksing. Chinksing. You know, Lloyd Best used it, you know, when they, in a different political context, Madam Speaker. And I want to make reference to the Hansard of the Senate, at page 129 of the 11th of the 12th, 2018. And this is what the Honorable Attorney General had to say. My problem with introducing the indemnity provision that the new clause 4 suggests, that this is a provision which was introduced by Senator Wademark, is that we do not yet have an opportunity to do the consultation with other stakeholders that really ought to be caught in this basket. So I think it's a noble suggestion. I think it really ought to be something that is applied across the board, but then again, one has to balance the question, is there mischief to be had? And just saying, go ahead and do whatever you do because I will pick up your tab. Because the complete indemnification and exculpation of even a judicial officer is to allow them to do anything they want, regardless, because the taxpayers pick up the burden. Right now, there is in the Balancing Act the need for some sort of sword if you have acted maliciously and without good faith. Whatever you want to call it. So one could argue on the other side of the coin in the legislation, being judicious in approach, that perhaps you really ought to have a circumstance where civil liability does attract in some form or fashion. Now, how do you reconcile this statement of the Honorable Attorney General with the independence of the judiciary? How do you reconcile that? Because the executive is retaining a sword. How do you reconcile that? Madam Speaker, in my understanding of a liberal democracy and the context of the separation of powers, you cannot sustain a sword in the hands of the executive against the independent, impartial judiciary of this country. So, Madam Speaker, you know, in order for us to get an appreciation of where we have come from, to understand our 1962 Independence Constitution, our Republican Constitution, and the evolution of our society, we must recognize that preservation of the rule of law is critically important. But more so, Madam Speaker, we must also recognize that there is an evolutionary process in governance. And I thought I would bring to the attention of this House, Madam Speaker, a lecture given by Justice Adrian Dudley Saunders entitled "The Role of the Court of Appeal in Developing and Preserving an Independent and Just Society." Lecture given at the Trinidad and Tobago Judicial Education Institute in 2012. And I want to quote from page 24, Madam Speaker, a brief quote. Each generation of judges must examine and re-examine those printed words to ensure that their interpretation is in sync with evolving standards of humanity and with internationally accepted norms. Law must be certain and predictable, but it must also be just and evolve with the times. It is the ongoing role of the courts to resolve this delicate tension. The independence of the judges is constitutionally protected, and their fidelity to the law and constitution is not compromised by any need to please a particular constituency at their tenure. Judges must be sober, cautious, deliberate, but they must also be self-confident, courageous, strong, willing to go where no judge has gone before, if after mature consideration, that is the path one thinks right. Madam Speaker, I want to commend the reading of this to the Honorable Attorney General, if he has not done so before. Because the path we have to take, after 101 years of this legislation lying fallow, and given the evolution and the environment, as my colleague from St. Augustine said, the biosphere that we now inherit in the legal environment in Trinidad and Tobago, I think we need to provide immunity to magistrate equivalent to that of judges in this country. Madam Speaker, you know, it is in the protection of a democracy and the importance of the independence of the judiciary. It is not the protection of the magistrate we are looking at, Madam Speaker. We are looking at the protection of the public, because if the magistrate is protected, then law can be dispensed with judicially, impartially, fair, and the rights of the citizen can be asserted. That is the connection. The independence and the protection is the means to an end, not the end in itself. So I call upon, with these few words, Madam Speaker, with these few words, I call upon the Attorney General to take the approach of the Jamaican Act. It is entitled, the Jamaican Act is entitled, Madam Speaker, it is entitled, an act to amend and rename the Judicature Resident Magistrates Act. And it is in that act you have various nomenclature changes. Resident magistrate, and substituting, therefore, in each case, the word judge of the parish court. So the magistrate becomes a judge, as is happening in the criminal division. Magistrate, therefore, in each case, the word judge of the parish court. Resident magistrate court, substituting, therefore, in each case, the word parish court. And so on, Madam Speaker. And in Section 7A, you have in 2016, in a CARICOM country, in a country that shares the same Commonwealth history, that shares the same common law history, and shares the same jurisprudence, they are saying to their people that judges of the parish courts shall enjoy the same immunity from liability as judges of the Supreme Court. This is what we recommend on this side, and this is what will allow our democracy to grow and not be stifled, and the magistrates will not have a sword hanging over our heads as whomsoever that person might be, an attorney general who will cherry pick as to who he provides indemnity to and who he provides indemnity against. So I think, Madam Speaker, that we are in today the legislature. You have had the Court of Appeal of England. You have the Privy Council. You have the Court of Appeal of Trinidad and Tobago, the High Court judges. all over the Commonwealth saying that you need to have that harmonization of immunity between courts, so-called courts of inferior status and courts of superior record together, that the personnel must be protected so that the justice that will be meted out will be for the benefit of the people of the country. No more caste, no more class differentiation. Let us have an egalitarian approach to the provision of justice in Trinidad and Tobago. I thank you, Madam Speaker.
Member for Oropuchu West.
Thank you, Madam Speaker, for recognizing me as I join in this debate a bill entitled An Act to Amend the Magistrates Protection Act 2018, Chapter 603. Madam Speaker, before proceeding with the substantive issues in this bill, which is a very few amendments, I would like to congratulate the member for St. Augustine and the member for Chaguanas West, who were not only brilliant, Madam Speaker, but they demonstrated, I would say, a collective flair of perspicacity in their contribution. Yeah. Madam Speaker, we are here to deal with this bill that deals with the protection of magistrates. And one has to ask the obvious question, who are magistrates? What do magistrates do that warrants them this protection? And why should they be protected? Madam Speaker, we all know that magistrates are creatures of statute, meaning they act with limited jurisdiction and they have to act intra vires. Madam Speaker, this Magistrate Act is about 102 years old. Act 34 of 1917, amended by Act 45 of 1979. And if the Honorable Attorney General is bringing legislation, Madam Speaker, to protect one arm of the judiciary, I'm asking, why are you doing it piecemeal? You have an opportunity to bring something solid to the Parliament. You will recall, Madam Speaker, when we had done the Criminal Division and Traffic Acts Bill in 2018, it was debated on the 13th of April 2018 for the removal of the preliminary inquiries. We would have masters dealing with sufficiency hearings. And masters, too, Madam Speaker, will have to be listening to and dealing with applications from other attorneys, and they, too, can make errors. Are we going to bring a separate piece of legislation to protect masters? We know Court of Appeal judges, we know High Court judges, they all derive their protection from common law, Serious and More case. And Lord Denon said in Serious and More, no action is maintainable against a judge for anything said or done by him in the exercise of a jurisdiction which belongs to him. So I'm asking also the Honorable Attorney General, what about industrial court judges? What are we doing with these judges? Members of the Tax Appeal Board, and we have also commissions, the Equal Opportunity Commissions. We have the Judicial and Legal Service Commissions, Madam Speaker. What are we doing to deal with all these different judicial arms? So why don't we bring amendments that are all encompassing to these judicial officers? Why don't we expand the State Liability Act so the state will take up this burden? That is a question I asked the Attorney General, and he may want to respond to that later. But according to the Commonwealth Magistrates and Judges Association Constitution, Madam Speaker, a magistrate is defined as any judge of a court not being a court of unlimited jurisdiction in civil or criminal matters. In fact, Madam Speaker, magistrates play a very integral part in the justice system. They are deemed the foot soldiers of the judiciary. But, Madam Speaker, they do much more, because if we look at the magistracy, we see that it's comprised of 12 magisterial districts, as per the Summary Courts Act, we see that magistrate districts operate with a distribution of 18 magistrates' courts, and there are 46 members of the magistrates' court. There is 1 chief magistrate, 1 deputy chief magistrate, 8 seniors, and 36 magistrates. So what we have, Madam Speaker, is that magistrates, they perform a range of functions. They deal with matters from capital offenses right on to traffic offenses. And when we look at the annual report of the judiciary for 2017-2018, we saw over 165,000 cases were filed. And when we look at traffic offenses alone, Madam Speaker, there are over 102,000 cases in traffic offenses. We saw family matters, close to 15,000 matters. Non-capital offenses, over 28,000. And when we look at private summary matters, over 8,000. In fact, Madam Speaker, they even do petty civil.
May I invite you to look at Standing Order 55-1B, please?
Please continue, number 4.
Thank you.
Foreign officer.
So, Madam Speaker, what you will have is magistrates would have done approximately 10,000 cases per year. 10,000. So there's actually, Madam Speaker, if magistrates are performing so many matters, the probability for them to make mistakes increases. So there is that lacuna, Madam Speaker, in the law that magistrates can be personally held liable for acting outside their jurisdiction. In other words, magistrate must act intra vires and within the law. And I will deal with Clause 5, Madam Speaker, when we look at malice and when we look at reasonable and probable cause that have to be proven. Madam Speaker, if we have to have magistrates performing their job efficiently, they must be provided the resources to do it. They must be trained. And this takes me to a point from an article from the Morning Herald, the 22nd of November 2018, as recent as 3 months ago, where in New South Wales, where a magistrate succumbed to the stresses and anxiety of the field that she was, it means that so many applications was coming before her that she succumbed, she got depressed. She said that there was a crushing workload. Some days I had 45 seconds to deal with each charge, and it severely impacted her mental health. She continued, I simply could not get through the list without making mistakes. I was aware that I was extremely stressed and very anxious. So, Madam Speaker, it's similar to us in Trinidad. We have many magistrates that have to be running from San Fernando. Take, for example, Medina Court in San Fernando. They have to be moving from the magistrate court to the Supreme Court, the High Court. And they're working, Madam Speaker, like a junior sex system. I know the Honorable Attorney General on the last time took umbrage to it when Urupuch East spoke about it. But that's the reality, because the judge has to get up, his usher has to move out his books to make room for a magistrate to move in to do with the 2nd and 4th court and the 5th and 6th courts. So they are working under stressful situations and they are not being provided with the necessary resources. In India, another Commonwealth country, Madam Speaker, in Anwar Hussain and Ajay Kumar Mukherjee, AIR 1965 SC at 1651, held that the order of arrest and detention of the plaintiff was not made in bona fide belief in exercise of jurisdiction. The magistrate was found to have acted recklessly and maliciously, and the court awarded damages where the magistrate was personally liable. I'll give you a second example, Madam Speaker. South Africa. A magistrate had to pay 115,000 rands of damages plus interest out of her own pocket to a convicted fraudster after she refused to hear her bail application because it was in a language called Afrikaans. That is, the magistrate herself had to be held personally liable and she had to pay damages. And of course, we all know about our own local case here, Indar Jagru and Anisha Mason. Madam Speaker, if magistrates are to be protected, and we want them to be protected, they have to be equally trained. They have to have that training, because if they do not have the training, they are liable also to make mistakes. They may say things in open court which may be prejudicial to a defendant. And an action, a suit can be brought against them. So training is another issue, and that takes me to the status of magistrates in the Commonwealth's report, February 2013, at page 11. This is what they had to say about training and the reality magistrates face within the Commonwealth. And I quote,
I think now if you're going to deal with training, I think you're really bordering on irrelevance.
Okay.
Okay? So that either you restructure your argument or you go to another point, please, because we're not dealing here with training of magistrates.
Thank you. So, Madam Speaker, let's look at Clause 5. And I believe my friend from Chaguanas West already spoke about the Latimer principle, and where we talk about the independence of the judiciary. So I would not go there, and I will look at Clause 5, which says, Clause 4 of the bill seeks to amend Section 5 of the Magistrates Protection Act by shifting the burden of proof to the claimant to successfully bring an action. Essentially, Madam Speaker, the proposed amendment provides that once it is established that a magistrate acted outside of his jurisdiction, the claimant must specifically plead and prove the existence of malice based on the actions of the magistrate. And when we look at the case law of Manzano and the Attorney General, Madam Speaker, of Trinidad and Tobago at paragraph 46, the case is 2010, CV 2010, 2754. What was malice? Malice means not only spite or ill will, but also an improper motive. It is also recited in Gibbs and Rhea in 1998 AC at 768. Madam Speaker, to succeed in an action for malicious prosecution, a claimant is required to prove the defendant instituted or carried on the proceedings maliciously. There was an absence of reasonable and probable cause for the proceedings, and the claimant has suffered. This principle, Madam Speaker, has also been followed in Lister and Perryman, where they dealt with probable cause, which consists of such facts and circumstances as would lead a reasonably prudent person in like circumstances to believe the plaintiff guilty. So, Madam Speaker, those who listen to this trying to figure out, what does this mean? What does all this mean? What does all this mean to the ordinary, reasonable man? It simply means, Madam Speaker, by having this clause here inserted, it means that a citizen's rights are eroded because of this provision. This is what it means. Because it will be very difficult, Madam Speaker, for any litigant to sue a magistrate based on malicious prosecution. Because what are the ingredients, Madam Speaker, for malicious prosecution? It is very difficult to prove. There must be some sort of balance, Madam Speaker, for the magistrate and the litigant, because a person's right must be intact and kept intact under the Constitution and not infringed upon by some hurried amendment. In fact, Madam Speaker, every time a judge makes an error of judicial decision cannot be equated with malice. So how is it that a litigant can go and prove malice? It is one of the most difficult things to do. What would you say? Would you look at the demeanor of the magistrate to say he was that was malice? would you look and say, well, he said something during the trial to the aggrieved party, and that is malice? Those things are so subjective, Madam Speaker, it's very difficult to prove. And that might prevent a litigant from bringing an action, a suit against the magistrate. And even if he were to bring that action, it is difficult to prove because now the burden shifts to the claimant and he has to prove malice. Madam Speaker, but when we talk about the concept of protection and immunity, we have to ask, do they really deserve it? One school of thought said that magistrates' protection should be equivalent to the protection afforded to judges. In an article dated 2016, a former judge of the Guwahati High Court in India, Madam Speaker, Sridhar Rao, said, can judges get blanket protection? Can magistrates get blanket protection? And he said, the need for judicial immunity was advocated by Justice Edward Coke in Floyd and Baker, 77 English Report at 1305, for judges of the higher courts for the reasons that in every litigation there will be one losing party and a winning party. The losing party is always likely to blame the magistrate or judge concerned, and the controversy is bound to embarrass the judicial officer. Besides such persistent onslaught on the decision, on these judicial officers will shake the will and independence of the judicial arm.
Correct.
So, Madam Speaker, in course of time, he said protection of judicial immunity must be extended to all judicial officers. When we look at the Criminal Division and Traffic Courts Bill in 2018, which was piloted here by the Attorney General, Madam Speaker, we saw that the Attorney General from the bill and 2018 Traffic Division and Traffic Courts Bill Act, magistrates are going to sit in a criminal division court as district judges. So this perhaps is an anomaly, because how is it that the same person sitting as a magistrate and adjudicating on matters, and he makes a wrong decision, can be sued, while you as the same person, magistrate sitting as a district court judge, in the same magistrate court, you have blanket immunity. So this has to be reconciled. And Madam Speaker, the government believes that, or the bill has been brought here, that magistrates should enjoy the same privileges as judges of the High Court and Court of Appeal. And now we have heard that these two amendments, Madam Speaker, when we look at the two amendments to this bill, they really don't give the magistrate 100% immunity. So you have, again, a lacuna existing because you do not have 100% immunity. It is just like what the Honorable Attorney General said once, that there is no absolute right to privacy. So this means that the magistrates themselves have what is called only qualified rights and privilege or immunity. Right. So, Madam Speaker, with those few words, what is important is that the bill, clause 5, we need to maintain the rights of citizens. We have to give them that liberty, and their right in Section 4 should not be infringed, and they should still have that right intact so they can bring an action against the magistrate in the event that they are aggrieved. And with those few words, Madam Speaker, I thank you.
Member for Laventille West.
Thank you very much, Madam Speaker. Thank you very much, Madam Speaker. Madam Speaker, today the discussion before us has largely to do with the magistrates in our jurisdiction. Of course, as a former colony of the United Kingdom, we inherited, for what it was worth, some of the vestiges that we still manifest from our former colonial masters. But as a consequence of the leadership of the PNM, and of course, in particular, Dr. Eric Williams and a number of intellectuals who he gathered around him, we forged a way beyond that. And in some ways, we retain some of these elements, and one of them is the establishment and the existence of the magistracy. Just for the benefit of the record, the Office of the Justice of the Peace, otherwise called magistrate, can trace its origins back to the reign of Richard I, who appointed keepers of the peace to enforce the law. Justice of the Peace, as a title, came into existence during the reign as far back as 1361. Madam Speaker, in its originality, they had the power to restrain offenders, rioters, and as it was then called, barraters, to pursue, arrest, and take and chastise them according to their trespass or offense. In other words, Madam Speakers, had the UNC been around in 1361, the justices of the peace would have dealt with every one of them. It was in 1835 that the Municipal Corporations Act empowered boroughs, and we still have those today in Trinidad, to request the appointment of paid stipendiary magistrates. At first, these magistrates were not required to have any formal legal training, but today, we've heard, and it is a fact, that magistrates must now be an attorney at law of at least 5 years standing. So we know that. And of course, I was just reading from a document that came out of that jurisdiction. The first female magistrate in England was appointed in 1919. And of course, the majority of magistrates in England today, lay people as they for the most part are, untrained in law, but bringing a common and local feel to the jurisdiction, they are female, as indeed is the case here today. The magistrates in Trinidad and Tobago today, Madam Speaker, have, as the member for Chaguanas West correctly pointed out, if it's the only correct thing he shared with us today, a very significant caseload. And for that reason, while we speak glibly and loosely in some cases of them, they deserve our highest commendation as a people of Trinidad and Tobago, and I would like to join in commending them and thanking them for the work that they have carried on for the benefit of this country. Many thousands of cases, traffic matters, petty civil matters, preliminary inquiry matters into serious crimes, including the capital offense. And of course, petty civil, as I said, I think they have a jurisdiction of up to $15,000 or $18,000. You can resolve your matter in the magistrate's court. So they do serve this country and serve quite well. But of course, even today, in 2019, they are treated differently, as has been established in the course of this debate today. And there's an argument that they ought not to be treated that way, and many jurisdictions have moved away from treating them as a second-rate bunch, and in the particular case that is before us today, not providing them with the indemnity and the protection against personal suit and against personal liability when they act in accordance with their functions as magistrates. That really essentially is the issue before us here today, and a lot has been said so far about it. We've heard the word jurisdiction used over and over again, and some citizens may think that jurisdiction speaks about a country or a territory simply or simpliciter. That, of course, is not so. The word jurisdiction is a highly complex term, and it has exercised the minds of courts in England and around the world on many occasions. I recall, just very briefly,
every point the member for Laventille West has made, I've heard it at least 5 occasions. Thank you. 5 occasions. Relevant?
Please continue.
Yeah.
Might I proceed, Madam Speaker? Madam Speaker, one of the major cases that I recall dealing with this business of jurisdiction is the case of Anisminic Limited and the Foreign Compensation Board in the UK. Yes, a very old one, but it was very decisive in deciding about this business of jurisdiction. And according to the now common understanding, Madam Speaker, jurisdiction, though it has very many meanings, in the context of that which we speak in this, means the power and authority constitutionally conferred upon a court or judge to pronounce a sentence of the law or to award the remedies provided by the law upon a state of facts proved or admitted, referred to the tribunal for decision, and authorized by law to be the subject of investigation or action that tribunal, and in favor or against persons who present themselves or who are brought before the court in some manner sanctioned by law as proper or sufficient. That is the given definition of it. And there are a number of cases which grappled with this question of jurisdiction, and I think it was important for us to, at least for those members of the public who listen to us, to understand what we mean. It is the power of the court under law to act and to make decisions. So when we talk about within jurisdiction and without jurisdiction and ultra vires, we are talking about the court or the tribunal acting within the power that is accorded to it under law. And if it acts outside of jurisdiction or outside of the law, then, of course, that has its own implications. The problem for us today, which the Attorney General and the government is attempting to resolve, is that while these magistrates are serving in the public in the way we describe, making very important decisions, deciding in some cases on items of property, on people's liberty, on all kinds of issues. They do not, Madam Speaker, enjoy the indemnity and protection that judges of the jurisdiction enjoy, and therefore they are at risk. And we heard ad nauseum about the Jagru case and the so-called Jagru effect by my friend, the member for Chaguanas, who argued against this bill in essence and who argued for it, going and coming. He was within and without jurisdiction whole day. He wasn't sure. And it is one of the reasons why I tried to clarify that issue. But, Madam Speaker, he argued all sides of his face, if I may use a metaphor. But the current arrangement...
I think sometimes it's difficult in one sentence to repeat the honorable member. All right? So I say that as an overall warning, but also member for Laventille West, please be guided in terms of referring to your colleagues that we do use honorable member or member for whatever.
I thank you again, Madam Speaker. But, Madam Speaker, as it now stands, the understanding is, as the magistrate decides on the facts and on the law, and on the combination of the facts and the law, as the magistrate must often do, to come to important decisions affecting, as I say, liberty and property in this jurisdiction, the understanding is that he or she could be held personally liable and be subject to suit if they act within their jurisdiction, without their jurisdiction, or even within if they act with malice or bad faith or ill will. The member for St. Augustine had difficulty, and the member for Oropouche West, with this question, this old and time-worn issue of malice. The law books, the cases are replete with the use of that concept, and the courts of this country, the Commonwealth, and the world would have exercised themselves over the use of the term and an understanding of the term malice so many times. It is documented and written. I can't see what problem they would have. I heard both members for St. Augustine and the member for Oropouche tell us here today that it is the most difficult thing to prove right here. The member for Dago Martin West had a matter against the Integrity Commission of this country where he had to go to clear his name in the court. And Madam Justice Rajnath Lee, as she then was, I seem to recall, found that that entire Integrity Commission acted with malice, or what she called on that occasion, misfeasance, malfeasance. This is well known to us. So I can't see what is troubling my friends so patently on the other side. The ingredients, and they are in the habit of acting in a certain way. You see it. Just, you look on the record. Madam Speaker.
Member for Laventille West, there's a certain innuendo in what you've just said there that borders on a breach of the standing order. So I'll ask you to say that in a different way.
I thank you very much, Madam Speaker. Let me withdraw it. Let me withdraw that. Madam Speaker, the member for Chaguanas West told us that the amendments that we propose here today, two simple amendments to Section 4 and Section 5 of the Magistrates Protection Act, they do not go far enough. I listened carefully to the member to find out how far should we have gone. But of course, I am obliged to remind him and his colleagues on the other side that they were in government for 6 years between 1995 and 2001. The member for Siparia was Attorney General during that period, but for a brief while. They did nothing about the status of affairs with the magistrates. They were in government from 2010 to 2015 in the month of September.
Madam
5
Speaker,
years and 3 months.
Stand on 48.1, please.
We're talking about the magistrates.
Please continue.
They did nothing about the very act. Today, the Attorney General, on behalf of the government and the people of this country, recognizing that there is a serious issue which arose most poignantly in the matter of with Magistrate Jagru. And then they criticize and tell us it doesn't go far enough. The member for Chaguanas West accused the Attorney General of chinksing and said to us, now is no time to chinks. Now is no time to play on the defensive. You should be firing the bat all around the field. Open up and hit the ball while they're waiting on the boundary to catch and run away with the ball, you know, and grab the stumps, you know, and take the bat too. If I may use his metaphor. And that's one of the reasons why people are afraid to hit the ball with them. They will take it. Madam Speaker, he accuses the Attorney General of cherry picking. He reminded me immediately of the member for Princestown. Once he said that, but I'll tell you why later. No, I can't tell you now. There's no cherry there. No, I will talk about that when I'm ready. I'll talk about that when I'm ready. But, Madam, I will tell you that when I'm ready, member for Siparia. I know you're curious to hear now, but I'll deal with that. But he accused the Attorney General of cherry picking. In other words, yes, the honorable member did that. In other words, what the member for Chaguanas West was saying to the national community on this floor is that the Attorney General was making these amendments, passing law to deal with one case, one magistrate. In fact, I overheard the member for Siparia. I overheard the member for Siparia saying, imagine they're making the law for one person. I heard the member for Siparia. If I'm not speaking the truth, she's free to get up and deny it.
Please. This is from the crosstalk. Member for Laventille West. Please direct your contribution.
Thank you. So that is what I understood the member for Chaguanas West to be talking about cherry picking. I simply want to say to him, the member for Siparia, and my friends on the other side, this is not about ad hominem law. This is not about one person. This is a principle. This is a principle. And that's where we come from. Principle. Madam Speaker, that's where we come from. And Madam Speaker, he identified correctly this dichotomy between the magistrates and judges, and he went as far as to call it a caste system. I just wanted to point out to him one minute difference. We have many examples of magistrates making their way to become judges in this jurisdiction. That is hardly possible in the caste system. His metaphor is inappropriate.
Great point.
Inappropriate. So, Madam Speaker, let us look at the parent act, the Magistrates Protection Act, Chapter 603. And it tells us that this is an act, the existing law is an act that is designed to protect magistrates and justices from vexatious actions done by them in the execution of their office. I just wanted to mention in passing, while the amendment today is to accord legal protection or protection from legal action and personal suit and liability, magistrates in this jurisdiction, as well as many others, are also the subject of physical threats. The law books are replete with those. And on this basis, only in passing, some judges enjoy all high levels of security. I think we are at the point, if I may say so in passing, that magistrates should enjoy that too. But that's not what we're here for today. I recall 3 magistrates coming to see me in an earlier time to discuss the simple business of maybe diplomatic passports and them being accorded.
You know, your last comment showed that you were trying to regulate yourself in accordance with the standing orders.
Yes.
And I suggest you continue that way.
Indeed.
With respect to this point you're going to embark upon.
Indeed.
Okay?
Thank you, Madam Speaker. Indeed. Indeed. And of course, in the Parent Act, Section 3 tells us, every action to be brought against any magistrate for an act purporting to have been done by him in the execution of his office shall be brought in the High Court. The amendments that we propose here today is to effectively protect the magistrate from such actions unless, of course, he or she is acting with malice or malafides or with misfeasance, which is, I take it, the sword that the member for Chaguanas spoke about. He raised the question of this sword, and he took one simple line, dicta from the Attorney General's potent presentation in the Senate, and hung on to that to suggest that the Attorney General was saying he wants a sword. The government wants a sword over judges, and that is a serious threat to the independence of the judiciary and a threat to the democracy of this country. My God, how trifling. How trifling. But of course, it is quite clear in all of the law that we quoted for the entire day today that if the magistrate is found to be acting with malice, malafides, then naturally some sanction must apply. And if that's the sword he's talking about, it exists everywhere. And there are means for removing judges from office if they are found to have acted in that and other ways. So I'll come back to that particular amendment in a very short while, our particular amendments. As for the member for St. Augustine, Madam Speaker, he accused the Attorney General and by extension the government of being deceiving. And he suggested that rather than attempt, as we are doing today, to amend the Magistrates Protection Act, we should have done it a little more differently. We should have done it differently by expanding the remit of the State Liability and Proceedings Act. I want to say to the member, and that act is to be chapter 802. Where's my phone? Now, I just want to take a quick look, Madam Speaker, if you would permit me, since the member for St. Augustine raised it, at the said State Liability and Proceedings Act, which the member suggested as their first speaker, we should have expanded its remit. That act says, Madam Speaker, in Section 3, under the rubric Substantive Law, where a person has a claim against the state after the commencement of this act, and if this act had not been passed, the claim might have been enforced subject to the grant of a fiat of the President by petition or right, or might have been enforced by proceedings provided by a statutory provision repealed by this act, and it goes on. More poignantly, Section 7 tells us, yes, where the state, I'll tell you just now, where the state is subject to any liability by virtue of this part, the law relating to the indemnity and contribution shall be enforceable by or against the state in respect of the liability. So it contemplates liability and it exempts some stakeholders from such liability, which a private person could ordinarily have enforced or enjoyed. It is now attached to the state. The member for St. Augustine is suggesting that we could have expanded the remit of this act and include the magistrates in that much more easily than we have done today. But of course, even if you try to expand it, to include it in the definition of servant, the magistrate will still be sued and have to deal with the consequences of that. So I want to suggest to my friend, that is not the most efficient way to do it. And we, this government, as a matter of policy, considered that an amendment to the Magistrates Protection Act would be the best way to deal with this. Now, the existing act at Section 4 tells us that the endorsement of the writ or summons in every such action shall allege either that the act was done maliciously and without reasonable and probable cause, or that it was done in a manner not within the jurisdiction of the magistrate. So that you'll have to plead that it was not within the magistrate's jurisdiction. But very often, the act complained of is done within the magistrate's jurisdiction. And if you can't prove that it was done outside, you have some difficulty. You have difficulty from the very start. It goes on to say, or otherwise the writ shall be set aside on summons. And if the plaintiff fails at the trial to prove the allegation, a verdict shall be given for the defendant. We are amending that provision today, Madam Speaker. And we are saying that that Section 4 should be amended to read, it should be repealed altogether, and the following subsection substituted. 4.1, the new subsection, no action shall be brought against a magistrate for any act done by him in the execution of his office in relation to a matter done within his jurisdiction. Now, of course, if he acts outside of his jurisdiction, you can have an appeal against his decision. So the member for Oropuch West wondered what would happen if he acted outside of his jurisdiction and whether there will be no remedy. Of course there'll be a remedy. There's an appeal against that decision. But when he acted within his jurisdiction, well, there might be some, but you You have other ways you can treat with it. I'm just responding to the member for Oropouche West. And it says in sub 2, nothing in subsection 1 shall in any way impair the availability of other forms of relief in respect of decisions of courts of summary jurisdiction, including appeals, applications for judicial review.
Member for Laventille West.
Madam Speaker.
Honourable members, it is now 4:30. We'll take the suspension now. This House is now suspended. We shall resume at 5 p.m.